is under the weather and unable to appear today, and to the extent that there are needs, the Deputy Executive Director will serve in that role. Item number 2, which is the principal agenda item, which initially, when this agenda discussed, is the presentation regarding the potential need for and implications of imposing limitations on candidate-controlled ballot measure committees and or legal defense funds. And this is pretty much staff directed, and I appreciate, I believe we have some guests who are going to provide us with some input. Thank you.
That's correct. Good afternoon, Commissioners. Jesse Minardi, Deputy Director. You'll recall that earlier this year, the Commission resolved to investigate whether to propose a ballot measure imposing limitations on committees that are controlled by city candidates and office holders, which are not directly related to their campaigns for office. These types of committees include candidate-controlled ballot measure committees, which raise and spend funds in support of or in opposition to particular ballot measures, candidate-controlled general-purpose ballot measure committees, which raise and spend funds in support of or in opposition to various, generally unspecified measures, usually over a number of election cycles, and 3, legal defense funds, which allow a candidate to raise funds to pay for legal expenses associated with litigation resulting from his or her candidacy. By way of background, there are generally no limits on how much these committees may raise from any particular donor, although certain city contractors may be prohibited from contributing. Also, unlike city candidate campaigns, corporations may generally make contributions to these candidate-controlled committees. This item today is part of the Commission's due diligence and further exploration of this issue. We are very, very lucky to have 2 experts today who will tell us more about these types of committees, how they are used by candidates, and whether, as a policy matter, certain restrictions may be advisable. Our first speaker today is Bob Stern. Bob has been called the godfather of modern political reform in California. He was the principal co-author of Proposition 9, otherwise known as the Political Reform Act of 1974, which continues to form the basis of California's campaign disclosure, ethics, and lobbying laws, and which are generally incorporated into San Francisco laws. He was also a principal drafter of the City of Los Angeles's ethics and public campaign financing laws. Bob served as the first general counsel of the Fair Political Practices Commission and was later the president of the Center for Governmental Studies based in Los Angeles. Bob has been honored for his public service by a number of good government groups, including the League of Women Voters of Los Angeles, Common Cause California, Pomona College, and the Council on Governmental Ethics Laws. Bob is a graduate of Pomona College and Stanford Law School. Our second speaker today will be Corey Cook. For the last 6 years, Corey has been an associate professor in the Department of Politics at the University of San Francisco, where he has also served as the director of the Leo T. McCarthy Center for Public Service and the Common Good. Corey teaches courses in American politics, specializing in political institutions, urban and state politics, and the dynamics of political representation. His early work concerned campaign finance reform, and his current research focuses on election results and political geography in California. Corey is considered an expert on San Francisco politics, and he frequently shares his views on Bay Area TV and radio programs. He is widely quoted by national and local publications, including the San Francisco Chronicle and the New York Times. Corey has also provided expert testimony for the city in the past concerning its adoption of ranked choice voting. Corey was recently named the inaugural dean of Boise State University's College of Public Service, and he will assume that position this summer. Each of the speakers is going to make a presentation, and then we'll take questions from the Commission in order. So we will start with Bob Stern.
Well, thank you very much, Mr. Chairman and members of the Commission. It's a real pleasure to be here. It's such a beautiful day, too, here in San Francisco, and congratulations on last night's victory. Now that the Clippers are no longer in the playoffs, I am rooting for the Warriors, so congratulations. as indicated, I had worked for the FPPC for 9 years and went down to LA in 1983 to serve as president of the Center for Governmental Studies. The Center was a nonprofit research organization that studied campaign financing, the initiative process, redistricting, term limits, and came out with a series of reports and recommendations on how to improve campaign financing. One of our reports, Money and Politics in the Golden State, we studied San Francisco, we studied Los Angeles, we studied 18 cities and counties throughout California in terms of their campaign financing. This was in 1989 that we came out with the report. And as far as we know, it was the first book that ever looked at city and county campaign financing practices. We actually went to Alturas, where the biggest campaign expenditure there was for a personalized license plate, paying $50. But we recommended major changes in the law in L.A. After our book came out and after a scandal involving the mayor, passed a public financing and campaign finance law based on our recommendations in the book. CGS closed 4 years ago, and I've been semi-retired since then, working as a consultant occasionally and appearing as a speaker in several events. About 12 years ago, CGS came out with a report dealing with candidate-controlled ballot measure committees. And we urged the Fair Political Practices Commission to adopt a regulation saying that a candidate-controlled ballot measure committee should have contribution limits apply to it. They adopted the regulation, but in fact, one of my former colleagues, Chuck Bell here, challenged the regulation in court, and the court ruled that the FPPC did not have the authority to issue the regulation. The court did not address the constitutionality of the regulation, just that the commission didn't have the authority. As far as I know, no other jurisdiction has adopted a contribution limit on a candidate-controlled ballot measure committee, but I think that they should, and I think that you should seriously consider it. The purpose of contribution limits is to reduce the actual corruption or the appearance of corruption when candidates receive campaign money. In my view, there is no difference between a candidate or office holder raising money for his or her own campaign as compared to a candidate or office holder raising money for a campaign for a ballot measure if the candidate controls that ballot measure committee. A donor giving to a candidate or an office holder really doesn't care how the money is used. The donor only cares for the gratitude that the donor gets from the candidate or the office holder. The donor, at the very least, wants access to that office holder, an hour of time with the official. At the most, the donor wants a decision in his or her favor, although few, if any, donors will link the money to the decision, because, of course, that's bribery, and most people know that not to make the actual link. It is our estimate, and when I was at CGS, we would study campaign financing statements, particularly in the state, that 90% of campaign money comes from people who want something from government, a decision or time with the official. Of course, there are contributions from friends or relatives who only want to support the candidate, but that's the minority of money. Most of the money comes from people who want something from government. Campaign money comes from labor unions that may be negotiating contracts with local government. Campaign money comes from developers that are asking for permits or variances. Campaign money comes from businesses that are seeking tax breaks. Campaign money comes from companies that are bidding on contracts. All of them want the support, or at least the ear, of the official. If you allow unlimited contributions to candidate-controlled ballot measure committees, this is a way to circumvent the contribution limits that you have in effect for candidate-controlled committees. A lot of office holders get involved in ballot measure committees for many reasons, sometimes to promote or oppose the issue, sometimes to enhance their standing or reputation among their constituents or voters, sometimes as a way to raise more money from the special interests. But the contributor to a candidate-controlled ballot measure committee may not even care about the ballot measure, may not even support or oppose it. The contributor only cares about his or her relationship with the official. In some instances, the contributor may be from out of town and has no idea what the issue is about, but gives the money anyway because the official asked for it. Now, some will argue that it is unfair that a candidate-controlled ballot measure committee should have limits, whereas non-candidate-controlled committees don't have limits. Because as you know, the United States Supreme Court has ruled that in the Berkeley case in the 80s, the ballot measure committees can't be corrupted. It is unfair to the candidate or office holder, but it's also unfair that candidates and elected officials can raise money from people who merely want to influence the candidate or official, as opposed to supporting or opposing the ballot measure. Let's turn briefly to legal defense funds. I'm less concerned about legal defense funds, since the FPPC has some extensive rules on how they can be spent. You have to have a pending investigation or a case against you. You can't raise legal defense funds in anticipation of something in the future. Still, it is unfair that an office holder has access to money that you and I don't have. If I were sued for remarks made today before you, I couldn't go to the special interests and ask for financial support. They would laugh at me. But if I were an office holder, the special interests would be lining up the door to support me and my legal defense fund. So I think the fundraising for legal defense funds should be strictly limited. They should have the same limits as candidate committees. The bottom line, if you want to have meaningful contribution limits for candidates and office holders, you need to support a limit on candidate-controlled ballot measure committees and a limit on contributions to legal defense funds. Any committee the office holder or candidate controls should have contribution limits. So I'd be happy to answer any questions or respond to any comments you might have on my remarks.
Mr. Stern, I do have one question. I just want to get a definition understood. When you talk about a candidate-controlled ballot measure committee, does that committee have to be a committee that is focused on a specific ballot measure, or are we talking about some general fund that the candidate sets up a committee to say, I want money so that I can decide which ballot measures I want to make contributions to?
I think it can be either way. Either one. Any committee the candidate controls should be subject to contribution limits if you have contribution limits, and you do.
And when you say candidate controlled, it's because it's the candidate who has the ability to direct where the funds go?
Yes, that's correct.
Would you be comfortable with different limits for candidate-controlled committees versus legal defense funds versus contributions to a candidate's campaign? Or is it the fact that there are no limits to the controlled committees?
I would prefer that they be the same limits because you've already indicated what the limits, or somebody has indicated what the limit should be for a candidate-controlled committee. So I would make it the same limit apply to everything. But if it meant that there would be no ordinance or no law, I would go for a higher limit if that's the other alternative. But it seems to me that once you decide what the limit is going to be for a candidate-controlled committee, you should say, well, that's the limit for any committee that the candidate controls, whether it be a ballot measure committee or a legal defense fund. Now, I know at the state level, there are no limits for the legal defense funds. They have to report them, and they're very strictly regulated. If I were writing this was not what I wrote in the Political Reform Act. This was after I left. This was several years later that they imposed this. But I would impose limits at the state level as well on legal defense funds. Any committee the candidate controls, no matter what it is, for legal defense fund, ballot measure committee, general purpose committee, whatever, any committee should have contribution limits attached to that committee as long as the candidate controls it.
Do you think that a limit on legal defense funds will deter in any way good folks from running for office?
No.
I mean, if they know that if they are faced with some frivolous lawsuit that they can't raise money to defend while they're taking a salary, that is maybe a lot less than they otherwise could get in the private sector to perform public service, Isn't that potentially a problem?
I would assume most people don't think they're going to have a legal problem when they run for office. But secondly, if that person loses, that person's not going to be able to raise money other than from friends or relatives. It's only those who win that are able to raise the money, and it's from the special interests. So I don't think so. Now, the one thing in terms of the candidate-controlled ballot measure committees, my guess would be, and this is a guess, that if you impose contribution limits on candidate-controlled ballot measure committees, the candidates won't control the ballot measure committees. There won't be any, so it won't be a major problem. But it's the symbol of it almost, where a candidate just should not be raising money for committees they control beyond the contribution limits, in my view.
Mr. Stern, do you have an outstanding, egregious example of this, of someone who possibly participated in this kind of activity, and what was the outcome? Does an example stick out to you of either on either one of them, the campaign, the candidate-controlled committee, or the legal defense?
Yeah, I'm going to let Mr. Cook talk about San Francisco because I'm not that familiar. But Mayor Villaraigosa in Los Angeles raised several $100,000 from people for a education ballot measure, and he would not have been allowed to do that if it were his own committee. And the limits were $1,000 in Los Angeles. And he was raising $25,000, $50,000, $75,000 from the same people that would have given money to his campaign. Governor Schwarzenegger in 2005 was raising substantial amounts of money for his ballot measures and well above the limits from the special interests. Again, I think in many cases, not in all cases, but in many cases, these contributors would not be giving to the ballot measure except for the fact that the office holder was asking for that money. And that's the problem I see.
Thank you.
But how is it any different than if the candidate told these donors, I want you to contribute to this campaign, and they go ahead and do it? Isn't he getting the same benefit?
That's a really good question, and you're absolutely right. It's almost getting the same benefit. The difference is that when they give to the ballot measure committee, the candidate, number one, doesn't control the expenditures of that committee, and number two, the candidate doesn't get the benefit of perhaps other expenses being made by that committee for lawyers and for other things that might, in a sense, help the candidate as well. But you're right. I mean, if a candidate asks you to give to another committee that they don't control, you still may feel obligated to do that. But I do see there's a difference between a committee that is controlled by the candidate and a committee that's not controlled by the candidate. And so I think it's a step in the right direction. If I had my druthers, I would say, the candidate shouldn't be asking for money from the special interests at all, but I'm not going that far.
How common is it in California, for example, at the local level, like San Francisco, LA, any others, where these separate committees are set up, candidate-controlled committees for ballot measures? My information was that we only have one in San Francisco, and that's the mayor who has one. But how common is it that these are done?
I don't think it's terribly common, but the mayor of Los Angeles as well. So it looks like mayors and governors like to do this sort of thing. And I think that if there are no restrictions placed on candidate-controlled committees, you're going to see more and more of it happening. And that's why I think that you should step in and say, no, we don't think this should happen in San Francisco.
Now, you said that when you tried to do it at the FPPC level, you were told, hey, you can't do it. Why do we have the power that the FPPC did not have?
Well, you don't have the power to do it by regulation, I don't think. You do have the power, I think, to put it on the ballot and have the voters approve it and put it in the charter or an ordinance, and that would be a different situation. And I think that would be okay. But to do it by the FPPC just didn't. The court said didn't have the power to do it by regulation because of what the statute didn't give them. Didn't talk about ballot measure committees. But if the statute does, then the statute it's not your power. It's part of the statute or the ordinance or the charter amendment.
Any other questions from any of the commissioners? We've got some time limits, partly due to the room accommodations here in the City Hall. But I will try to have public comment limited just to the testimony of Mr. Stern so that you can respond to it, so that, but it should be limited just to questions or comments addressed to the speaker. Do we have any public comments on that, on Mr. Stern's comments?
If I might just say, Chair Rennie, Mr. Stern, thank you for your.
I haven't gotten there yet.
Thank you for your time. Your name is often invoked here, and it was actually a pleasure to finally hear you speak.
Charles Marsteller, speaking for Friends of Ethics. Mr. Stern is my political mentor of about 20 years, so it's good to see him. I did have an indirect question, and I'm wondering if there's an analogy that can be drawn between the need to impose loan limits for loans to candidates in a contest and other types of issues that might arisen with legal defense funds or other types of entities that candidates might invoke that essentially have the net effect of obligating them possibly in the future to a party. That is why this body back in 2000 put loan limits on the ballot with Prop O's revision of the CFRO. And it was pointed out that loan limits, if they're not capped, might in fact obligate a candidate who's running for election, if they're elected, to be beholden to special interests and raise money essentially in a way after the election when they might have more cachet to do so, to pay back their loans or otherwise be obligated to the person that they're beholden to. So that's why I'm wondering if there's an analogy to be drawn between, say, legal defense committees and loan limits on limits or contribution limits on loans to candidates.
Thank you. Any other public comment?
Larry Bush, also for Friends of Ethics. I provided each of the commissioners with a spreadsheet with some information, but touching on 2 points that Mr. Stern just raised. One is the advantage for an office holder to have a committee like this as opposed to people giving directly to ballot measure committees. If you can have a committee like this, it allows you to keep intact the political infrastructure of campaign consultants, lawyers, paying for polling, and also make a decision yourself as to where to place ads so that they go to places that you're likely to have a good relationship with. And that's what we have seen with the Mayor Ed Lee for San Francisco committee, because unlike the other 3 that I was able to identify since 2007, that was a committee that was involved in supporting a number of ballot measures. So any donor could have given to any of those other ballot measure committees directly, but instead gave it to Mayor Lee's committee, who then gave it to the other ballot measure committees. So you have to ask yourself, what was the advantage of that? And then you have to look and see, as I've given you a spreadsheet, how much money people contributed to and who were they. The contributions were as high as $30,000. Over a 3-year period, there's one donor who gave about $65,000. That's a lot of money from people who also have strong interest in city policy and strong financial interest in city policy. So I support all the things that Mr. Stern said, and I have 30 years' experience, Charlie.
Thank you.
Good afternoon, Commissioners. Anita Mayer from the law firm of Pillsbury, Winthrop, Shaw, Pittman. I would like to make a few comments regarding proposals to impose limits on contributions to candidate-controlled ballot measure committees and legal defense funds. Based on case law, I believe limits on contributions to candidate-controlled ballot measures are unconstitutional. The U.S. Supreme Court ruled in Citizens Against Rent Control v. City of Berkeley that limits on contributions to committees formed to support or oppose ballot measures violates the First Amendment. In reaching this conclusion, the court stated the following. 1, the practice of persons sharing common views, banding together to achieve a common end, is deeply embedded in the American political process. 2, the freedom of association is diluted if it does not include the right to pool money through contributions, since funds are essential if advocacy is to be effective. 3, to place a limit on individuals wishing to band together to advance their views on a ballot measure while placing none on individuals acting alone is a restraint on the right of association. 4, contributions by individuals to support concerted action by a committee advocating a position on a ballot measure is a significant form of political expression. And 5, the contribution limit automatically affects expenditures, and limits on expenditures operate as a direct restraint on the freedom of expression of a ballot measure committee. The integrity of the political system can be adequately protected through public disclosure. In Citizens to Save California versus the FPPC, the issue was whether contribution limits could be imposed on candidate-controlled ballot measure committees through the FPPC's regulatory scheme. Because the appellate court held that the regulation conflicted with several provisions of the Political Reform Act, the court's decision did not address the constitutional issues raised by such limits. However, a close review of the case would lead one to reasonably conclude that the court would have invalidated such limits as unconstitutional. Citing to the Berkeley case, the court noted that the risk of corruption perceived in cases involving candidate elections is not present in a popular vote on a public issue. The court rejected the FPPC's argument that contributions to candidate-controlled ballot measure committees are presumed to be contributions to candidates. Such committees are formed to support or oppose ballot measures, not the controlling candidates. Such restrictions would limit the electorate's ability to work in tandem with elected officials to effectuate the electorate's public policy concerns. As the court concluded, a contribution to a ballot measure committee, even if controlled by a candidate, typically is a contribution for the passage or defeat of the initiative. The general appearance is that of support for or opposition to the initiative, not the candidate. And I just have a couple other comments about legal defense funds. One of the issues the Commission should consider regarding limits on contributions to a legal defense fund is that such limits may have a negative impact on the quality of legal representation provided to the officer or candidate, or whether the officer or candidate can even afford legal representation. Several local jurisdictions, such as Contra Costa County, Fresno, and Oakland, do not impose any limits on contributions to separate legal defense funds. If you decide that limits are needed, you may wish to follow the precedent set by numerous local jurisdictions which permit contributions up to a specified amount.
I think you've exceeded your time and you have it in your thing. Mr. Stern, do you want to respond to the argument that there are some constitutional problems raised by our putting a limit on a candidate-controlled committee?
Clearly, there is a constitutional question. There's no question about that. And I can't predict what this Supreme Court would do, but it seems to me there is a major difference between a committee, a ballot measure committee, as was in the Berkeley case, and a committee controlled by a candidate. And it seems to me the court would say there is no difference between a committee controlled by a candidate that is making expenditures for ballot measures as opposed to a committee controlled by a candidate making expenditures for the candidate's behalf. But as I say, you can't predict the Supreme Court. I think I think the court would uphold it, but there is a constitutional question.
Okay. Any other public comment at this point? All right. Well, thank you very much, Mr. Stern. I appreciate, as Commissioner Herr said, we appreciate your testimony, and we may be calling on you on other matters if we can.
Thank you again. Thank you very much for inviting me to come up here. I really appreciate it. Please feel free to call on me at any time. I'm semi-retired. I'm happy to answer any calls from your staff or from you, and feel free to give me a call. Thank you so much for allowing me to come up here.
All right. Professor Cook.
Thank you, Mr. Chairman and Commissioners. Thank you for the opportunity to be here. It's an honor to be here with Bob Stern, whose work I've admired for quite a long time. I began studying campaign finance issues in California in 1994 when I was doing research for the state legislature, my first job out of college, on campaign finance issues. I've done research on public financing systems when I was in graduate school, and I've studied political reform in California and in San Francisco in particular since becoming a political scientist at San Francisco State, now at USF. I cannot offer you a legal perspective, but more a political science one. So I can tell you sort of a little bit more about what the data say and also about sort of what political scientists will tell you happens with ballot measure campaigns. Beginning with Buckley, as you know, the courts put the prevention of corruption and the appearance of corruption at the center of its campaign finance rulings and about the efforts to regulate campaign finance. In recent years, the court has interpreted corruption according to a pretty narrow definition, focusing on bribery and quid pro quos, which I would argue is insufficiently broad way of understanding corruption. But nevertheless, the focus has been on distinguishing between direct and indirect speech, and therefore regulating contributions to candidates and elected officials has been a primary focus in campaign finance. The logic of San Francisco's contribution limit set at $500 is to deal directly with this concern about corruption of the elected official or the candidate, or the appearance thereof. So in my view, in essence, allowing for unlimited and unregulated funds to flow through candidates and office holders to use on ballot campaigns is a clear circumvention of these limits and a clear distortion of the purpose of campaign finance law, as are behested payments, by the way. But I realize that's a subject for another day, and I appreciate the extent to which San Francisco actually does have some transparency around behested payments that the jurisdictions do not. At least those are transparent. To be clear, I'm not accusing any individual candidates of wrongdoing or suggesting that any candidate who's created a candidate-controlled committee has participated in a quid pro quo, but the appearance is certainly striking. And I would argue just as importantly is the opportunity for voters to increase their cynicism and disengagement from political processes as a result of these systems of financing. Candidate-controlled committees are fairly widespread now at the state level. In 2009 report, the FPPC estimated at the state level, legislative and statewide candidates raised over $150 million for ballot measures in the first 8 years since Prop 34 was in place. So that report was in 2009. The commissioner asked for examples. Governor Schwarzenegger had his Citizens to Save California. The largest single contribution to that committee was $1.5 million. His expenditures also gained some public attention. Reportedly, he spent $523,000 on executive jet services out of that committee, which was what gave rise to the FPPC and the court cases that Bob mentioned. The FPPC does, at the state level, at least regulate contributions to ballot measure committees controlled by candidates to the qualification, passage, and defeat of ballot measures, which is something I understand San Francisco does not yet do. Still, Schwarzenegger went to the ballot repeatedly with some success and some very notable failures. The current governor has taken this to new heights. He raised $17 million for Props 1 and 2 in this most recent go-around, and $42 million for Prop 30, the largest donation of which was $1.5 million. One of my concerns is for voters, it's exceptionally difficult to discern or to keep track of these various contributions. For example, there's the $1.5 million contribution was from Californians working together to restore and protect public schools, universities, and public safety. And that donation was to Yes on Prop 30 to protect our schools and public safety, a broad coalition of teachers, businesses, labor, law enforcement, and the governor. So it was a $1.5 million contribution to a Jerry Brown-controlled committee, but for a voter, you would have no idea where the money came from or really where it was going to. At the local level, I've looked at 6 candidate-controlled committees, and I think you have that spreadsheet in front of you. There's some variation between them. The smallest one was the Proposition E committee that raised $38,000 from 5 donors, the largest of which gave $15,000. The largest of which was the Prop B committee in 2010 that raised $1.1 million. The largest single donor was $172,000. So there's a lot of variation. Most of these were for single ballot measure campaigns, although there is the one that is currently in the mayor's name is a multi-measure committee. The thing these things have in common is that the top donors give a lot of money. As was stated earlier, the largest to the mayor is $64,000. There was a $250,000 donation to Prop D in 2011. Most of the donors give more than $500, so the majority would exceed the current contribution limits. The majority of donors also give to the candidates directly as well as to these committees. Most of the time, these donors could have also contributed directly to the ballot committees that were not controlled by the candidate, and in many cases do give both to the candidate-controlled committee and not candidate-controlled committee, which gets to Bob's point about what it is they might be after and giving to both. And in most of these cases, the candidate took the money and then distributed the money to a variety of sources, oftentimes to these other committees. So again, from the public's view, it's very difficult to track where the money went and to whom and for what purpose. But it certainly, in my view, gives rise to the potential for the appearance of corruption and the possibility, if not the reality, of quid pro quos. There's a substantial political science literature on ballot propositions and the emerging phenomenon, particularly since the 1980s. It began in California, of elected officials and candidates turning to ballot campaigns to run sort of quasi-campaigns on behalf of issues. The research shows that these campaigns have profound spillover effects. They set the agenda and prime voters. What I mean is that these ballot measures raise the salience of issues that are on the ballot. So candidates around the country have figured out that if you can qualify ballot measures, that voters will actually be primed on those issues and will have measurable effects in terms of how they view candidates, even when those candidates have nothing to do with those issues at stake. So you raise issues around same-sex marriage, immigration, affirmative action, which are sort of the big ones we've seen around the country. And then it turns out that voters say those issues were important in their evaluation of pick a candidate race, even if that candidate had nothing to do with those issues. So a lot of the strategy around these things is to actually build the salience of these issues so it will affect other candidates on the ballot. We also know that voters these things will raise the awareness of candidates. So candidates can bring ballot measures forward, take positions on these issues, and then their own public awareness will rise. So then when they're on the ballot later, the public will see them in a different light. It's a way of sort of making a campaign expense about your future candidacy without actually having to do so. So in my view, it's a good public policy decision to subject candidate-controlled ballot measure committees to the city limits for candidate contributions. I think the court's concern is about the free speech rights of donors. I agree with Bob that in contributing to a candidate-controlled committee, that they are not speaking directly; they're speaking indirectly to the candidate, and as such, to me, those don't raise those freedom of speech concerns. I think there's always an opportunity to create independent ballot committees that are independent from candidates, that donors can contribute to address the concerns that were raised in the Berkeley decision and others, that candidate committees have been seen as, at least by the court, as not subject to this concern about corruption or the appearance of corruption, but those committees can exist independent of candidates, so that once you've actually allowed candidates to create committees, that they should be subject to the same contribution limits as if the candidate were running their own campaigns through them. So, thank you.
Questions from any of the commissioners?
Dr. Cook, thanks for your testimony. If it turns out that a limit on candidate-controlled ballot committees is unconstitutional, just for the sake of argument, what else can be done to mitigate some of the concerns you found in your research?
Well, I think what you're left with then is various forms of disclosure, right? So if you cannot limit the contributions, and all you can do is make them as one is ensure that they're actually being spent on, regulate where the money is being spent, that is being spent to qualify or advocate for a particular ballot measure. And so candidates can't sort of, in effect, these have been used in some jurisdictions as, in effect, another whole committee that can be coordinated with a candidate, right? And so at the very least, you can ensure that the money that's being spent on them is limited to being advocacy on those ballot measures. But I think also there's more you can certainly do around disclosure. Because for me, going through, as probably all of you have done, playing with the state data on campaign finance, which is an adventure in and of itself, it's very difficult to discern where the money goes. And I think San Francisco's done a pretty good job, particularly recently, of trying to make data more accessible to voters so they can understand it and can track it. But it's kind of a maze for voters. And I think, so at the least, you need to be doing more around disclosure. But I think you also can regulate on the money side. If these are going to be allowable, then at the very least they have to be spent on what they're being said to being spent for, and not being spent on sort of more generic things that might raise the profile of candidates or be used to pay other expenditures for campaign consultants that happen to work for both the candidate and the committee and things like that.
Are you aware of any jurisdiction that you've studied or know about that you think does this well?
Which part?
The disclosure
No.
and the regulating of where the money goes?
No. I think, in general, I've been really generally pretty pleased with how San Francisco manages its public data and tries to do disclosure on campaign results and campaign data and things like that. It has gotten substantially better here in the last few years. I mean, trying to dig through older campaign, as probably all of you are aware, trying to dig through older disclosure reports is kind of is pretty mind-numbing. So it's gotten a lot better here, but no, I think frankly most jurisdictions have not prioritized making those data available to the public in a clear and timely fashion. And the state is perhaps the worst offender.
Well, call me crazy, but would it just be out and out unconstitutional to forbid candidate-controlled ballot measure committees? Is that just a freedom of speech issue?
It's a great question. So I think, so we want candidates to be able to give their positions on issues, and I actually think, limiting the contributions that they can accept would not limit their freedom of speech to advocate on behalf of ballot measures. I do think you have a problem if you say candidates cannot. I mean, I guess if you were to do that, you could argue that a candidate could accept contributions into their own committees to advocate on behalf of ballot measures. I don't think it would be wise. I actually don't know what the argument would be for. Again, the contribution limits in San Francisco, I think, are sufficiently high that candidates can run well-financed, effective campaigns, and yet sufficiently low that they do avoid the appearance of corruption. So to me, we're sort of in that the sweet spot of having them be high enough that you're not limiting the ability of candidates to run compelling campaigns, and yet not so high as to be utterly meaningless. To me, I think you would run into First Amendment concerns if you said, or what you would do is you'd have candidates who are raising money for ballot, these general purpose candidate committees that I don't think you want. I think you're actually better off having separable committees if they're going to advocate for ballot measures. I just think that money should be regulated.
This may be hard to Dr. Cook to answer. Out of all or the majority of candidate-controlled ballot measure committees that ultimately achieved the desired outcome for that candidate, what percent do you think actually would be in violation if we moved forward with these restrictions, whatever the campaign dollar amount would be?
Well, I ran the numbers for San Francisco, so that's actually fairly easy. I mean, for example, if you were to look at the committee for Prop A that was, as I understand it, the Pest Control Committee in 2007, 148 of the 224 contributions were over $500. Mayor Lee's committee, 52 out of 53 contributions are over $500. Other committees like the Prop D committee, 78 out of the 188 donors were over 500. So again, it varies, but for the most part, these committees are not within contribution limits, and that's true at the state level as well as at the local level.
Any other questions by the staff? Any public comments specifically directed to Professor Cook? And thank you very much, Professor Cook. And again, as I said, we look forward to working with you not only on this, but on future occasions.
Larry Bush from Friends of Ethics. In terms of the disclosure issues that Professor Cook just raised, I suppose it's possible to create a disclosure form for these committees that require the donor to indicate what financial interests they have before the city. We already have disclosure forms that require you to say that I'm an American citizen, or I'm this, or I'm that, I'm a resident, however the form is, and adding a statement that alerts the public that this donor had a financial interest that was ahead of that official might be one way of doing it. A second approach is what was done under the Oak Project, which apparently is still enforced in some cities, in which the office holder is banned from making a vote that has a financial interest for a donor. So instead of banning the donor, you ban the office holder from making a decision that affected the financial interest of the donor. So I don't know what Professor Cook might think of that approach, but it is in place in some other jurisdictions. Thank you.
You want to respond to that, Professor Cook?
I think I just got a research project to go learn more about those things. So I don't have an opinion. I'm interested in learning more, so but thank you.
Okay. Go ahead.
In terms of the Oaks Initiative, Pasadena is enforcing it. It's not quite what Mr. Bush said it was, but it's a little different. Basically, if the office holder votes on a project involving money, a variance, or a contract, the office holder is then prohibited from receiving campaign money for the next 5 years or accepting a job from the person, from the company that appeared before the office holder. So it's sort of after the fact. This is the most anti-incumbent provision I've ever seen because it doesn't apply to challengers, it only applies to the people who are voting. And so office holders really hate it. But in Pasadena, it's worked quite well. The city attorney and the city clerk advise the office holders in terms of what votes they've taken and say you can't receive these campaign contributions after your votes and can't take jobs afterwards. So it's something to look at. It's not quite dealing with the ballot measure committees, because we're talking here about the candidate-controlled ballot measure committees, but it's an interesting approach to take a look at. As I understand it, San Francisco had it at one time, and then it was repealed several years ago.
Any other public comment?
Charles Marsteller again. I wanted to thank the chair and the commission for allowing public comment after each speaker. I think that's useful. I also wanted to thank Dr. Cook for his very interesting testimony. I did want to say on today's agenda, just for the public record, we have a question regarding a possible candidate-controlled committee dynamic. That's under contention, but it basically was comprised of two donations, as I understand it, one in one large amount and one in about $50,000 amount, totaling $191,000 or so. And I just wanted to mention that because the professor did mention that he had looked at that data, and it's certainly current on today's agenda as well. The last thing I wanted to say was that I've heard many citizens come to me, knowing who I am, I guess, and advocate for the $500 limit because they don't want to write a larger check and they don't want to be asked for a larger check. And I'm sure that some of the commissioners have had this issue come up and felt a sense of relief as well. I certainly support tying it to inflation, but apparently the public in the city is very happy with $500 limits.
Good afternoon. David Pilpel speaking as an individual. I wanted to comment on Commissioner Hur's question and Larry Bush's follow-up. I think two of the approaches here are to limit contributions to these types of committees or to ban contributions from certain individuals under certain circumstances. I think what I heard, though, was the possibility of a third approach to prohibit an office holder from taking certain actions following a contribution from a particular individual that would benefit them for presumably some period of time. And I'm not sure how well that option has been explored. I'm not sure that that was what Pasadena does, and perhaps there could be some further discussion of that approach and the pros and cons of pursuing that, because you certainly could allow, as we do now, individuals to contribute, but then limit actions that office holders can take that might benefit those individuals. And that could involve direct decisions or decisions of their appointees or others. So just a thought. Thank you.
Any other public comment? All right.
Mr. Chair, I just want to say from the staff and from everybody's, thank you very much to our two experts. And we, in keeping with the playoffs, we got a little present to say thank you to Bob and Corey. It's not the Clippers.
No, it's okay.
Go Warriors.
I think on this item there is not any action that we're to take at this particular meeting. This was really an informational gathering meeting. And again, I do appreciate the willingness of Mr. Stern and Professor Cook to come and provide us with their insights and the public comments that we've received. So with that, I will move on to item number 3. Discussion and possible action regarding further changes of the San Francisco Campaign Finance Reform Ordinance amendments, which were approved by the Commission on January 26, 2015. And do you want to present that?
Sure. Thank you, Mr. Chair. Yeah, Jesse Minardi, Deputy Director. So this is a follow-up from something that the Commission had passed back in January and then ultimately in February, and this was the sort of the streamlining, improving of the third-party disclosure rules, as well as the disclaimer rules, and then the removal of some older limits that we thought were unenforceable. And as an update to that, at the Rules Committee hearing last week, this matter was considered. It's been sponsored by Supervisor Breed. It was considered by the Rules Committee, which included Supervisor Avalos and Supervisor Tang. Supervisor Cohn was not there. And it was passed. So it was passed by the Rules Committee and sent to the board. The board, and Andrew will correct me if I'm getting the procedure wrong here, but the board will consider the package on the 9th. So on Tuesday. But at the meeting, there were two issues that generated discussion, one of which was re-referred back to the Commission for reconsideration. And then there was a second matter which was not re-referred, but Supervisor Avalos requested that the Commission just reconsider it as well. And these would be two changes to the amendments that you approved back in January and February, and they're actually, to be honest with you, they're not huge aspects, but they're big enough for generate interest by the supervisors. So really, they're before you again, and what we can do is I can just explain to you sort of the state of where the amendments are right now, what the request is by either both the committee and then Supervisor Avalos, and then the Commission would reconsider, if it wishes, those two items, or one or both, or neither. And then the intention is that when the board, the full board, actually hears this on Tuesday, Supervisor Avalos could make a proposal for an amendment. And because this commission has approved these two if you approve it, if it is approved, then it doesn't have to come back to us, and the board can sort of approve the whole thing as one big package, so that it would take effect, probably sometime in July, and then staff could get ready for the transition.
Yeah, thank you. I think it would be most helpful to deal with them separately. In other words, there are two proposed changes or additions to what the package is before the board, and I would propose that we'll deal with them separately and take motions on them separately. so let's take the first one, the one that came from the committee.
From the committee. Okay, sure. So the first one has to do with the 24-hour reporting requirement for electioneering communications. And so you may recall, just by way of background, we generally deal with three types. We generally regulate three types of communications and campaigns. One is independent expenditures, where you're actually saying more or less vote for or vote against a particular candidate. That triggers reporting primarily under the Political Reform Act, but then under our own law as well. Then there are member communications, which are communications distributed among like members of a trade association or a union or a political party, which again usually say vote for, vote against. So we have a reporting regime here in San Francisco as well for that. Then the third type, which is what this is about, is electioneering communications. And these are communications where there's no explicit sort of ask to vote for or vote against a candidate, but the candidate's name is featured on a mailer or a radio ad or a TV ad within 90 days of an election on a communication that's distributed to 500 or more people. And this is, we have a reporting requirement currently. And this, so we proposed to change that reporting requirement to require that it be $1,000 spent per candidate would trigger reporting. And so that's what the Commission approved. And the question was, that was referred back to us was, what should be reported on those reports? And when staff, again, staff didn't have a particularly strong opinion on this, but when staff was weighing this, we thought it was probably best to just sort of mimic what's reported on the state form, which is essentially just, how much was spent, what it was spent for, was a mailer or whatever, and who did they support or oppose, that sort of thing, and when, within 24 hours. There is currently a vendor reporting requirement. So you would now, under current law, have to report sort of who is getting the payment and their name, address, that sort of thing. So that was not part of the original proposal, and this is something that they are sending back and asking the Commission to reconsider, so that the form for electioneering communication will be a little bit different than, say, what we would normally do for independent expenditures.
Why did the staff delete that requirement about the vendor information that the board committee is now suggesting that we restore to that provision?
Well, it was primarily making it a 24-hour reporting requirement, and staff's basic experience is that this was not information that generally people were interested in, that people sought out from staff over a number of years. And a lot of times that information is available. A lot of times these are ballot measure committees. So a lot of times that information is already available on the ballot measure committee reports. And so in the interest of, making this 24-hour quick turnaround disclosure, staff weighed it and said, our experience is that people just want to know how much money is being spent and for what, not sort of, what printing press they use, that sort of thing. But again, it's not something that we feel particularly strongly about one way or the other. So it is before you again.
Any commissioners have any questions or comments on this particular item?
I have a question about the procedure at the board. So they're going to take this up on the 9th. If we were to say, yes, we amend per Supervisor Avalos's request, then
this is a committee request.
The committee request, then, but it passed out of committee. it did pass out of committee.
Do you want to? Yeah.
Yeah, so it was a little complicated. So currently what's at the full board, so what was actually passed from the Rules Committee to the full Board of Supervisors for consideration on Tuesday, is an unamended version of what this commission previously approved. No changes whatsoever. Now, at the time the committee met, I'm not sure the members of the committee were aware that we already had this scheduled meeting, because obviously this is not our regular meeting time. And so because they didn't have knowledge of that, they actually duplicated or divided the file, and in the duplicated version made this change, this vendor payment change that Jesse just described.
What does that mean in the duplicated version?
Yeah, so it really is just just like it sounds, it's like a version that was sent back to the Ethics Commission for its consideration. But simply by virtue of the fact that we do have this special meeting available for consideration of this matter, there is actually sufficient time to get back to the Board of Supervisors by Tuesday with whatever the Commission's view is.
Okay, so I understand what happens if we approve the proposed amendment. What if we don't? Then what? The package is already before the board and they vote on that, then can that be amended at that point, or is that?
Right, so the bottom line, in terms of leaving aside sort of the complications about what a duplicate files and all that, the bottom line is that whatever the Commission approves today, either one of these two amendments, maybe none, maybe both, whatever the Commission approves today can be put forward on Tuesday as a potential amendment at the Board of Supervisors. If the Commission does not approve either, the Board of Supervisors cannot make further changes. It will essentially be an up or down vote on Tuesday.
Okay. Thank you.
Sure.
So you're saying that at the board level, if somebody raises the same question about why did we eliminate that, and board members think that it would be a good idea, they can't send it back to us and say, how about considering adding this to it before we vote on it?
Oh, that's a fair point, Chair Rennie. I mean, I suppose if the other board members who, for example, aren't on the Rules Committee at all,
right, so
had no chance yet to weigh in on this, has additional amendments they want to make, have additional changes they want to make, yes, I don't want to rule that out. There could be, they could send the whole thing back to the Ethics Commission with, another raft of requested changes. But at least these are the changes that the staff is currently aware of, as voiced by the members of the Rules Committee.
Thank you.
Any other?
Yeah. Did it make it out of rules unanimously?
Yes, it did. Although that was sort of necessity. There's only 2 members of the Rules Committee, and so it's a 3-member committee, so you needed 2 to move anything forward. So yes, unanimous by necessity.
Yeah, got it.
Do I hear a motion from anyone as to whether or not we should accept the recommended amendment or not accept it?
I think based on what I'm hearing from staff and from reading this, I too don't think it's a huge issue. But if the purpose was to make it consistent with what state law requires, this is a form that does have to be fulfilled quickly on a 24-hour turnaround, and we don't really have a lot of evidence that the information has been hotly requested in the past. I mean, I do see that there's a balance between wanting to make sure we have good, adequate, fulsome disclosure, but also make it not unreasonably burdensome on those who have to complete these forms on a quick turnaround. So, I would be in favor of approving what we already sent.
Any second?
I'll second that.
Right. Public comment?
David Pilpel, speaking as an individual, I think I would agree with Commissioner Herr and not support making this change. I guess I'm also a little confused about the procedure. My understanding is that there are 4 steps required to amend the CFRO. 2/3 vote at this body, essentially a 4/5 vote, 2/3 vote of the board, findings that it furthers the purposes, and that it's in print for 30 days. I don't believe this amendment has been or will be in print for 30 days. This memo was only available on Wednesday, 2 days before this meeting, and presumably only 6 days before the board meeting, and this would obviate a further hearing at the board before a committee. So I'm just not sure if those 4 prongs will have been satisfied for these particular changes. But again, as to this first change, I would agree with Commissioner Herr and not support making this change at this time. Thanks.
Mr. Shen, isn't it a fact that what the proposed revision is just to reinstate what is existing rule at the present time?
That's correct. So the concept certainly has been in the ordinance of removing this provision. This draft ordinance, as you know, has been available for a long time. Previously, it was considered by the Commission several months ago. And I have consulted with the General Counsel of the Board of Supervisors, and he feels that the Board can consider this on Tuesday.
Okay. Any other public comment?
I'm Bob Planthold. I wanted to differ with this motion. You hear that this information is not widely requested. Maybe the fact that it isn't requested is because it's not required to be provided in the form that this amendment would have. And the point is, if you know it's not required, why request it? It seems to me that the evidence cited is a negative evidence. But separate from that, you talked of the possibility the board may request other amendments. If you send along this amendment, then the board has both versions, the unamended version and then the Rules Committee version that adds this amendment in. It could make it easier for the board to take action Tuesday rather than have them say, why didn't you do this? It would forestall a send-back. Just by sending this along, they have both versions, which they can then decide on the spot which to approve. If you don't send along this amendment, they may say, let's look into why it wasn't acted upon. It may forestall further action. I think the motion should be defeated, and a substitute alternative one is to recommend it to be sent along to the board.
Any other public comment? Before we vote on it, I want to say that my concern in supporting Commissioner Herr's motion is, it seems to me that we ought to be pressing for more disclosure rather than cutting out disclosure. And this, what we did with the proposal that is before the Board of Supervisors, and I've got to say I didn't focus on it at the time. I was not aware that we were cutting out a disclosure part of the present regulations. And I am inclined to vote against any resolution that sends a message that, well, we think information that was previously required is no longer necessary in these 24-hour turnarounds. So that I have trouble supporting the amendment, but I will call the question. Go ahead.
May I respond? And I hear your concern, but I think it is a trade-off. I mean, if you change the time from 48 to 24 hours, you are giving the public more information than we otherwise were. And so, as a trade-off, I think you're just requiring less information to be disclosed, but more often. And because on other forms where this has been required, we're not really seeing it being requested that often. I mean, I do think it's a good balance.
Any other discussion? I'll call the question. All those in favor?
Aye.
Aye.
Opposed? Aye.
No.
It show that it's 3-2 supportive motion.
Doesn't it have to be 4/5?
4/5 to make the change.
Not to make the change.
Yeah, not
It's 4/5 to make the
four
change.
to make the change.
Okay.
Because as it currently stands, it's already had the
Turn to The second item.
Thank you, Mr. Chair. So the second concerns an exemption to electioneering communications. So this is one that was actually suggested by at an interested persons meeting. And this would, what was approved was an exemption for 501c3, communications sent out by 501c3 charity organizations. Originally, the suggestion would be for all nonprofits if they were going to have a fundraising event and they sent out, invitations, and one of the sort of the guest speakers was a particular office holder who happened to be running for office that year, that would be exempted. We thought that was too broad because obviously there are a lot of nonprofits who can participate politically in political campaigns and do participate in political campaigns. The one exception that we noted is 501c3 charities, where are subject to strict tax rules, federal tax rules, that preclude them from doing anything that sort of sounds like, looks like that they are trying to influence an election. So the fact is that again, this is not a huge issue, in all honesty. But the issue that we saw was really sort of a trap for the unwary. So a 501c3 that has a fundraiser every October, always has an elected official speak. It just so happens on that fourth year that one elected official is running, if they sent out 500 invitations, written invitations, that said, please come and support us, make your deductible donation, they would have to not only file a report with us, but would also have to put something on that says paid for by, please see the Ethics Commission's website for more financial information. So again, not the biggest issue, but we thought all things considered, given the IRS rules on candidate participation, that in the interest of not being sort of a trap for the unwary, we would propose this exemption. So again, the Rules Committee did not request that the Ethics Commission reconsider this. There was debate between Supervisor Tang, Supervisor Avalos. They did not agree on this issue, but ultimately Supervisor Avalos did make a request, and we thought, certainly out of deference to him, we would bring it back to you.
Are these 501c committees, are those the so-called social issue committees?
No. So there are, nonprofit organizations, a whole other set of laws, but I do have some experience with them. 501c3s are charities, and unlike other organizations, the donations that you make to them are tax deductible. You as the donor can deduct the donations. And then, of course, they are not taxed as well. So, and again, as part of that, the IRS is very strict that you can't be involved in candidate campaigns. You can have let's say, debates between candidates as long as there's no sort of indication of support for one position or the other. But C3s they couldn't even have an endorsement on their website. The social welfare organizations you're talking about are 501c4 organizations where donations normally are not tax deductible. And those organizations are not at all precluded from being involved in candidate elections. In fact, can spend up to 49% in any given year on that stuff. Same thing with trade associations, labor unions. They also do have the ability to participate.
I have a question on this. So if we were to approve this, the committee didn't request it, does the whole thing go back to committee then?
I don't think so, right? No.
Yeah, sure. So very briefly, no, it doesn't require re-referral to committee. But like the first matter, if the commissioner were to approve this by 4/5, then it would be at least in play in terms of the board's meeting on Tuesday. The board could adopt it or could make that amendment, given that the Ethics Commission has already approved it. But if the Ethics Commission doesn't approve it, then the board can't make that change.
So what is the importance of pointing out sort of what happens at committee, what happened at the committee level?
I think that was just, I believe that the Deputy Director just wanted to provide you with some background on the committee's views and also on the respective supervisors' views. I believe he just thought that would be helpful for the Commission.
I see.
Thank you. Sorry. Yes, that's right. No, that's right.
Chair Rennie. I have to say I do support this, being a part of the nonprofit community for many years. In many ways, how it typically plays out is how Mr. Minority explained it. You'll have an annual gala. Generally on that invitation, you'll see an honorary host committee, and it's basically a laundry list of every elected official, and that's just symbolically in name only, and that's nice to have that kind of support. And then generally speaking, if an elected official is to come, it's usually because they're being honored for the community pillar or the community advocate, and in which case they would say some remarks after receiving that acknowledgement. Rarely are they pushing a particular issue or certainly not their candidacy, as they in many ways know that they cannot do that, and nor can the nonprofit do that. And those contributions that are made to that particular nonprofit are tax deductible. And you are right, there are very strict rules around how a nonprofit has to engage and behave with elected officials and such. So I do fully support this. In many ways, it could prohibit the engagement that a lot of supervisors have. It is a part of their well within their purview and authority and responsibility to be engaged with the nonprofits that are in their particular districts to understand what is going on the ground, to figure out where resources need to be directed, particularly for those who are vulnerable in San Francisco. And one of those ways in which they're able to do that is often to go to the gala to see, or these fundraising events, to see the level of support, the level of need, and to get a little more information from the ground level. So I do support this exemption.
Do you want to make a motion?
Sure. I move that we support this exemption within CFRO of nonprofits being exempted.
Any second? Second. All right. Any public?
I'm sorry. Should the motion be that we don't support changing what we've already recommended? Would that be?
I think that's right. Yeah.
Either way.
Either way. Yeah.
But I think the okay. Just.
I think his motion is that we support retaining the exemption that's in the proposed draft legislation. Okay. Any public comment?
Larry Bush for Friends of Ethics. At the time that this came up before the Commission, before we opposed this exemption, I'd like to give you a compelling example of how this works. A few years ago, when I was working at the Department of Housing and Urban Development, one of the groups that we funded as a 501(c) was a group called Third Street Economic Development Corporation. It was run by a fellow named Charlie Walker. They did one event a year, which was an annual fundraiser honoring Willie Brown's birthday. It was right before any election that he was involved in. Eventually, it was discovered that, in fact, they'd never done the paperwork to become a 501(c). However, by that time, HUD had already given them hundreds of thousands of dollars through the city of San Francisco. One way to avoid this kind of thing is simply to say that when you have an event that's going to give prominent attention to an elected official prior to an election, it should not be exempt. I understand exempting one of 20 names on a list, but when you're featuring somebody who's up for election, and it's not once every 4 years, it's once every 2 years, because everybody on the board, or half the board is up every 2 years, then it makes sense to say we're not going to allow it to be used as a platform to advance anybody. You could say the same thing for a supervisor who's strongly supporting AIDS funding, and so you have an AIDS organization that gives them highlight, which was a very good thing to do. but it's the wrong time. They can do it at any other time. This is only a 90-day window. This is not a window that goes all year long. Thank you.
Thank you. Any other?
Good day. Robert Van Ravensway speaking for myself. I'm just trying to follow what you're voting on here, because the third paragraph on the back of this memo really confuses me about what happened at the supervisors' committee meeting. It says Supervisor Tang was clear she was not in favor of removing this exemption, and the committee did not support this change at this time. Does this mean that, from her point of view, she supported the legislation that was placed before her, and
That's
then
correct.
Avalos asked after the meeting that the commission reconsider the exemption?
That's correct.
Okay. It's a little confusing.
Yeah,
here.
I hear you. I had the same question.
David Pilpel again, speaking as an individual. Once again, I support the motion. I think this is a reasonable exemption. The Commission considered this before. If the board on this matter, the previous matter, or any other matter wants to send you a request to amend the CFRO, I think that should be done separately. But I think this was really done in the context of all of those changes. And as was said, a 501c3 is subject to all kinds of other restrictions, and I think those are appropriate. And just an invitation that incidentally mentions an elected who may or may not be up for election at that time, to me, shouldn't be subject to the definition of electioneering communications and the disclosure requirements that attach to that. So I support the motion. Thanks.
Thank you. Any other comments? All right, hearing none, I will call the question. All in favor?
Aye.
Opposed? Hearing none, the motion is carried unanimously.
Well, I think we would stay in the room.
Turning to item 4, which is a discussion
Do I need to talk to Steve?
concerning the recruitment process. As you'll go ahead.
Sorry, Mr. Chair, I'm just going to recuse myself for the next two matters, so thank you.
As you'll recall, at our May 27th meeting, we reported that Human Resources had sent out proposal to 6 vetted vendors and had received only one, that being from Alliance, but with some indication that if we extended the time, we might elicit additional vendors from that 6. We did extend the time to noon today, and as of noon today, we have received no further responses to the proposal. Since our meeting on the 27th, we have conducted a sort of a review of the other ethics commissions within the state, and I think some out of state, to find out if any of them had used recruiting organizations in connection with the hiring of their executive directors, and with the exception of Los Angeles County, we were advised that none of them had ever used an outside recruiting company. We do not have, at this point, I don't have the name of the recruiting firm that was used by Los Angeles. We will get it. It was some 4 years ago, as our understanding. But we will get that to see whether that elicits a name of a organization that may have previously been involved in seeking to find an executive director for an ethics commission. It is our intention, and hopefully we can get the announcement out today, that Commissioner Andrews and I will be meeting with Alliance on either 3 o'clock on Tuesday this coming week or 3 o'clock on Wednesday this coming week, to talk with Alliance about their proposal to satisfy ourselves whether or not we think that they can adequately perform the job. And obviously, any member of the public is welcome to attend and to hear what they may respond and to provide with whatever input you may have. I believe that meeting will take place in one of the rooms provided by the Human Resources Department. Isn't that correct, what they thought?
At the current time, I still haven't heard back from DHR. They're still trying to nail down the details of location and time and also the availability of the consultant on the desired dates. And certainly we'll try to get that out as soon as we can.
But look to get some announcement either today or today is Friday, so the next would be Monday, which means we might have to shoot at a different day. But I'm trying to keep the process moving, and if we can get it out today, we can put it either for Tuesday or Wednesday to meet the time requirements. Any public comment on recruitment at this point?
David Pilpel again, speaking as an individual. That all sounds reasonable. I would encourage you to meet in City Hall, either in 421 or 034 or some other conference room. If it's a meeting at 1 South Van Ness, which it sounded like it might be, I suspect that might trigger a 15-day notice requirement, and I don't think you want to do that. So hopefully you'll find a room in City Hall. Thank you.
Right.
Thanks again to the chair and vice chair for the extra work that this is requiring.
We'll see whether we can find a room, where we can find a room. That's in the process of people looking for it. All right, turning to item number 5, discussion and possible action regarding staff's proposed revocation of a forfeiture letter sent to Supervisor Mark Farrell. You have as attachments the initial forfeiture letter that went out in December, and you have the draft letter from Mr. Bell. And I believe there was also a letter submitted just recently today by Mr. Sutton's office. And the question before us is whether or not the waiver letter that has been prepared and submitted by the staff, and what action, if any, you want us to take on that. A discussion?
Mr. Chair.
Yes. Mr. Keene.
Thank you, Mr. Chair. We had an extended discussion on this once before and voted down the request from Mr. St. Croix to have waiver. I don't see why we should do anything different today. Nothing has changed in regard to the things that we talked about. We're dealing with a situation having to do with Supervisor Farrell, where Supervisor Farrell took an illegal $200,000 campaign contribution. The evidence in regard to the chronology, which is unrefuted, shown in the letter of Mr. Bell, and also what we got from the other information relating to the contributions itself, is that the same individuals who ran Supervisor Farrell's campaign set up another campaign committee. They coordinated the two. They got $200,000 in campaign contributions, most of which was from two very prominent social individuals in San Francisco, $150,000 from one, $50,000 from another. That money was used in order to defeat Mr. Farrell's opponent. The committee itself was set up just a few weeks before the election by the same individuals who were involved with Supervisor Farrell. The money that they received for that committee, they used it basically mainly for hit pieces in order to elect Supervisor Farrell. That was something that was not ever disclosed by Supervisor Farrell. He was subject to a $500 campaign contribution. This is $200,000. A supervisor was elected to the city and county of San Francisco on the basis of an illegal $200,000 campaign contribution. It went through the Fair Political Practices Committee. They ultimately took a stipulation from the people who were involved, the salient people who were involved, members of Supervisor Farrell's committee and this other committee. Those people said that they were indeed coordinating the second committee that was putting out the hit pieces, and that was the recipient of the $200,000 illegal campaign contribution. On the basis of that stipulation, then we ordered forfeiture, which is the appropriate measure under the law when someone takes an illegal campaign contribution. They then have to forfeit that amount back to the city and county of San Francisco. In the meantime, what had occurred is an enormous amount of time had gone by in which the stipulation itself took place. I wish Mr. St. Croix were here, but I'm not going to talk about Mr. St. Croix since he's not here. But it's unfortunate that he's not here in regard to the matters that are before this commission. But essentially what happened is by the time the stipulation we were made aware of the stipulation, and by the time City Attorney Dennis Herrera was made aware of the stipulation, it was towards the end of 2014. The period for anyone to file in opposition to Supervisor Farrell had run by a few weeks. And as soon as that stipulation was filed, Mr. Farrell's lawyers, good lawyers, and so I'm not challenging anything that they did. They're very good lawyers. They did a hell of a job for Mr. Farrell here. They immediately then said statute of limitations for anything further, and therefore we are barred by the statute of limitations, and the city attorney is barred by the statute of limitations. At the same time, Mr. Farrell has touted the fact that somehow the stipulation by his people that they did all of these illegal things for him, that exonerated him. That showed that he was completely not at fault. And he still goes around, and his lawyer's letters still say, this was an exoneration of Mr. Farrell. Mr. Farrell had nothing to do with it. Mr. Chair, I'm reminded very much of something you and I will remember back in Watergate, when the early part of Watergate, when all of the stuff was coming out in Watergate, and you had the fact of burglaries and all of the illegal activities by the committee to re-elect the president. And they said there was this little character by the name of John Dean. He was the one who was responsible for all of it. It was not really Nixon. It wasn't any of the people around him. It was John Dean who was the one who sort of was blowing the whistle in regard to it. And the idea that somehow, like in the letters we've gotten recently, that the campaign coordinator for Mr. Farrell, a gentleman by the name of Mr. Lee, that he was able to solicit from two very socially prominent people in San Francisco, $150,000 in one instance and $50,000 in another, and that Supervisor Farrell had nothing to do with it, beggars belief. It just is beyond any kind of credibility whatsoever. So I think on the facts alone and on the chronology that we see, Supervisor Farrell, if one were to make a decision circumstantially on the basis of that, Supervisor Farrell was indeed behind this. Supervisor Farrell knew about it. Supervisor Farrell coordinated it. But even if he didn't, it didn't matter. Under the law, if his people and if his campaign committee went and set up this shell committee and coordinated with it to elect him, which that's undisputed, he would be liable for all of the responsibilities of it, including forfeiture. So that's been done. We have asked for forfeiture to take place. We have gotten a letter from Mr. St. Croix saying we should waive it, which is an outrageous request. Waiver of something where some ethical principle has been violated is generally done because there are some equities involved. We have little Susie Smith running for dog catcher in the Sunset, who, in putting in her disclosure forms, her font is too small. And little Susie Smith has never run for office before, so we say, okay, we're going to waive it. Or there's some sort of equities involved. There's no equities involved here. One of the original request was that the statute of limitations is not run. I look at this as, once again, as someone who's been a lawyer for almost 50 years, I look at the arguments that have been made by Mr. Bell, and if I were a judge, I would rule the statute of limitations has not run. And I think on that alone, we ought to leave it to see if Supervisor Farrell wants to challenge this on the basis of the statute of limitations. Let some judge decide, not us. We should not do it. In regard to any kind of equities, one of the things that I would point out is we've never seen Supervisor Farrell. If Supervisor Farrell wants us to waive something and is imploring our equities, which is essentially sort of throwing himself on the mercy of the commission, why has he never come here? Why has he not appeared before us and told us why he should waive things? All the more important and sort of exemplary of this whole situation, if Supervisor Farrell is saying that there's absolutely no question that he can be exonerated, that he would be exonerated, didn't have anything to do with this, why doesn't he waive something? Why doesn't he waive the statute of limitations or any claim on it and say, let's get it on, let's have a hearing, put the whole thing forward because I'm going to be exonerated? He's not doing that. He's not doing that because what he did was corrupt. And we have a supervisor sitting in San Francisco now on the basis of a totally illegal election back in 2010. The whole thing is sort of slid through nicely. And if we go ahead and say, oh, it's okay, we're going to waive it, then there's no question that all of the criticism that has been made in the past about people who are rich and powerful. Here we have a supervisor who's the president, who's the chair of the budget committee. If someone's got some juice and some power, they get away with things. If you don't, well, you're tough. You know, you're going to get hit hard about that 8-point font as opposed to the 10-point font. This would be a terrible message to send regarding the whole aspects of ethics in San Francisco and this committee's willingness to go ahead and enforce the basic ethical rules if we waive it. So I'm going to ask my colleagues, please don't.
Any other comment? Commissioner Herr?
Thank you, Chair Rennie. I think one thing that both sides in this dispute can agree is that the process was not handled well. I hear many complaints that Ms. Riley has lodged through her attorney. I hear some complaints from what Supervisor Farrell has lodged through his attorney. And I do hope that going forward, whatever the resolution, we as a commission look at this and fix this, because this was not handled right. And, the recent allegations about the commission learning about this in August, but somehow not being able to find it or missing it is problematic, very problematic. Chair Rennie, I do have some questions for the attorneys regarding the statute of limitations issue that I would like to ask if there was an opportunity for that.
I think before we do that, Commissioner Keene, do you want to make a motion?
Yes. Mr. Chair, I'd like to move that we overrule the executive director's request for waiver.
Do I have a second? I'll second. All right, now I'll have public discussion, but Commissioner Herr, do you want to say which lawyers you want to direct your questions to?
I did want to ask questions of Mr. Bell and Mr. Sutton. The order is less important.
Good afternoon.
Good afternoon, Mr. Bell. So, Mr. Bell, I've read what you've submitted, and I understand your argument is that there was fraudulent concealment, thus tolling the statute. You would agree, though, that the principle you're relying upon is agency, right? That you're not alleging that Supervisor Farrell knew. You're saying his agent knew, and as the agent of Supervisor Farrell, that is imputed to the supervisor. Do I have that right?
Well, that's certainly the principal argument we make. I think it's clear that Mr. Lee was Mr. Farrell's agent, and that would apply both for purposes of his admission and stipulation with the FPPC, but I think it also applies to the case of the fraudulent concealment.
How should we think about the scope of that agency relationship? So, certainly, the supervisor could be responsible for his agent's conduct, but not all the agent's conduct. I mean, if the agent is acting outside the scope, then arguably that agency relationship does not impute liability or knowledge to the supervisor. So how do I draw that line?
Well, I think it's a pretty easy line to draw. He was acting as an agent with respect to his campaign activities and has admitted that. And therefore, there's really no line to draw. That's a complete and total admission. With respect to the fraudulent concealment, I think our point is that at the time that Mr. Lee met with the enforcement agencies, he acknowledged actions. However, I think we could assume that a party could wait to determine whether the agency found those actions to be actionable or culpable. At a minimum, the FPPC made that determination in August of 2014, and so the concealment that occurred, I think, goes from the time of the act all the way to that point. That's giving him the benefit of the doubt on this, I think. I'm not sure I'm answering your question, but I think
that's
with
helpful.
respect to both the fraudulent concealment and the actions that were the violations of law, he was the agent of Mr. Farrell. He admitted that in the substantive matter, and that's decisive, I think.
What would be an action that Mr. Lee could have taken that would, in your view, have been outside the scope of the agency relationship?
Well, there's no evidence that I could find from the file that we got, and we got a redacted file of the FPPC, and I don't know if you have access to the unredacted file, but there's no evidence indicating that there were any cautions about the actions of any of these agents. I mean, I think, in fact,
I understand that's your view, but what I'm trying to understand is, in drawing the line according to the law, you're saying that Mr. Lee was acting within the scope of his agency relationship. I'm asking you a hypothetical question. So what does that mean? What would, in your view, be outside of the scope? What could he have done wrong that would be outside the scope of the agency relationship?
Well, that is hypothetical, and I don't know that I can really answer that. He was engaged in campaign activity on behalf of Mr. Farrell. He carried that campaign activity over into aiding the setup of an ostensible independent expenditure committee that wasn't. Now, he admitted that liability. In my opinion, other actors also engaged in that kind of an activity, beginning with a meeting in early September of 2010 when not only Mr. Lee, but Mr. Farrell and a couple of other people involved in the committee, and former Supervisor Alioto Peer all met. And very quickly after that, this Independent Expenditure Committee came to pass. An individual involved with Mr. Farrell's Finance Committee left that committee and became the principal officer of the so-called Independent Committee. So I think that, there's a whole web of relationships here of people who were involved with Mr. Farrell's committee directly, who became involved with this other committee.
Okay, let me switch topics. Do you have a view on the application of the discovery rule here? So it sounds like you're saying there was fraudulent concealment, the discovery rule should apply, that we should toll the statute during the time that we were not aware of the violation. Looking at 1.168, why do you think that gives us the authority to find that the discovery rule applies, given that, unlike other administrative statutes, it doesn't talk about the cause of action being accrued until it's discovered?
Well, I think that the fraudulent concealment doctrine is an inherent equitable provision that allows not only courts but your agency to not to be taken advantage of by the concealed efforts of parties that are in violation of the law. The fact that you don't have that, I would say that you can look to the case law. In fact, the Boatwright case, which concerned the Political Reform Act, which the San Francisco law incorporates, makes that pretty clear from a civil standpoint. So I think it need not be explicit in your ordinance that you have a fraudulent concealment tolling. I think the case law binds you on that.
Thank you. Thank you.
Thank you.
Any other public comment?
I did have questions for Mr.
Go
Sutton,
ahead.
if that was okay.
Yeah, go ahead.
And I don't know if anybody else.
Yeah, okay.
I have one question also for Mr. Sutton after Mr.
Commissioner Hurd, do you want me to respond to the agency and discovery questions?
I have similar questions for you, but I wanted to start with the discovery rule. So it sounds like you agree that we as a commission didn't learn about this until December 23rd, 2010, right? Based on your letter?
Exactly.
Okay. So if the discovery rule did apply, then you would agree that the forfeiture letter was sent within 4 years of that date, right?
Well, if those are the dates.
Well, right.
Yes.
Right. Okay. So tell me why you think Mr. Bell is wrong about the discovery rule. I mean, it is true we have lots of statutes of limitations where you don't have a provision that says, it only accrues after discovery. That's in lots of statutes. Right. I've heard an argument, and I know that the U.S. Supreme Court has weighed in on governmental agencies not really having these tolling provisions or a discovery rule, but clearly in other statutes that relate to us, we do have tolling for discovery. So why can't we apply tolling for discovery in this case?
Well, I think what's most important is that you would only toll if there was fraudulent concealment, and there was absolutely no fraudulent concealment here. Let me actually start with something else. Let me start with the Boatwright case that Mr. Bell spoke about, and all of the cases where the courts allowed the government to do an action, even though the statute of limitations had tolled, was when the violation wasn't discovered until the statute had elapsed. And it wasn't discovered because the defendant intentionally hid it one way or the other. In Boatwright, he kept something off a form. He kept something out of some documents that ultimately became available, I believe, in a different court case. In none of these cases do you have the government being put on notice, and I think that's the key word. It's about when is the government put on notice that something might have gone wrong. Certainly, what happens in a district attorney's office? They are put on notice that a crime might have happened. And what the law then says is the government, the city, the Ethics Commission, has a duty within 4 years from the date of the violation to take action. So you were put on notice in December of 2010 when the complaint letter came in, and then Mr. St. Croix sent a letter out in January saying, we're investigating. We're working with the FPPC on this. So January 2011, 3.5 years before the statute of limitations ended, the commission was looking at the matter. Now, at some point in the investigation, the bad fact comes to light. And certainly, the statute of limitations doesn't start tolling when that bad fact comes to light. The whole point of a statute of limitation is the government has to do its research, figure out what the bad facts are, and file charges within that time period. And there's no one who is claiming that the Ethics Commission couldn't have filed charges by October 2014. The reason why we're here, and the reason what I think several commissioners are upset about, is that the commission decided not to. The commission did the investigation. The commission was with the FPPC. The commission sat in on the interviews, reviewed the emails. Now, what we would say is that the commission staff came to the exact same conclusion that the FPPC came to, which is that Supervisor Farrell should not be held responsible for the actions of his rogue agent. Okay? So John St. Croix, and I understand that some of you don't agree with this decision, but he said there's a pound of flesh that has been gotten in this case. There's a significant fine, $14,500. It's been an incredibly thorough investigation, and Supervisor Farrell was completely unaware and didn't authorize this one person on his staff to send 3 emails. And because of those facts, the FPPC decided not to go after Supervisor Farrell, and your staff didn't. But the staff could have done it within the 4-year statute of limitations. There's no question. They chose not to. And to talk about agency, what I think has come up so much in the last 6 months is there's clearly a disagreement between some of you on the commission and your staff and the way things have happened. But the staff is the agent of the commission.
I think you've answered my question, but so I want to ask another question, which does relate to agency, but not in the way you're talking about. So why isn't Chris Lee acting in Supervisor Farrell's? Why isn't Mr. Lee acting within his agency relationship with Supervisor Farrell? I mean, I get that you're saying he broke the law, and that, of course, wasn't what Supervisor Farrell expected, but he was certainly acting within his capacity. It's not like he went off and we're trying to hold Supervisor Farrell responsible for, a drug deal that Mr. Lee did in some other instance. It does relate to his
Supervisor
to his work.
Farrell has never claimed that Chris Lee wasn't, doing what he did right as, it was about the campaign. Now, does he meet some formal legal definition of agent? That issue's never come up. That issue is not on the table. It is the FPPC using its prosecutorial discretion said, who are the guilty parties here? Who are the culpable parties? Who should we levy a fine against, and who shouldn't we? And agency wasn't really the question. As a general matter, when a vendor, a consultant commits a crime, right? It's an action that's not authorized, not known, and it's a crime. Again, we never had to discuss the niceties or the fine points of agency law. But when you're not authorized, the committee has no knowledge, and what you're doing breaks the law. I don't know that comes with an agency. But I think the more important point is I don't, with all due respect, think that whether his actions were within the agency is the right question. The question is that the FPPC looked at this, obviously, and they said whether he was acting as Supervisor Farrell's agent or not, It is not appropriate to fine Supervisor Farrell, given all the facts and the circumstances and a 3.5-year investigation. And then your executive director agreed with that conclusion.
So setting aside your view that the fraudulent concealment doctrine wouldn't apply here because there's no tolling available under this particular statute.
I'm not saying there's no tolling available. Where's the fraudulent concealment?
Okay.
Can
I ask my question?
I'm sorry.
So I want you to assume that the fraudulent concealment could apply, and if then isn't it relevant? And if the discovery rule could apply, then isn't it relevant whether Mr. Lee was acting as the agent of Supervisor Farrell? Because what I understand you're saying is, look, this is not Supervisor Farrell's issue. This is Chris Lee's issue. But if Chris Lee is Supervisor Farrell's agent, or if there's a dispute of fact as to whether that is true, doesn't that potentially relate to whether the statute of limitations should be told?
I'll be honest with you, I really don't understand the question, because the commission was put on notice December 2010, January 2011, whatever it was. What the law says is that an agency never, ever learns about a potential violation the day it happens. By definition, the district attorney's office or an agency is going to learn about the possibility of a violation at some later point. In other words, there's never going to be a full 4 years to research the issue. Maybe it's only a year. Maybe it's 2 years. So because the commission knew within the 4-year period, then it had a legal duty, and you have a legal duty, to bring an action by October 2014. Now, it might be an entirely different case if the commission and no one learned about this until September 2014. But we don't have that question here.
So how do you draw the line then? What if we learned on September 30th, 2014? That's before the statute before the statute ran. So why isn't that then enough?
Well, but here there were 3.5 years. And remember,
so where's the line? Is it 2.5?
The commission could have done we have all been involved in cases where the government, and I'm sure that the district attorney's office does it more than anywhere else, wants to preserve the statute. So what does the government do? They rush, they prepare the report, here would be a probable cause report, and they serve it simply to preserve the statute. Or they ask the defendant, will you waive the statute of limitations? That happens all the time. Here, it didn't happen because the commission, your executive director, made a decision to not move forward. So there's fraudulent. He could have done he could have brought charges by October 2014. He chose not to bring charges, and the most important point is the point you made. I do not know what goes on in closed session. So we do not know what the commission knew or didn't know about pending enforcement matters. I do know in other cities, the executive director makes a report every month in closed session to his or her commissioners about all pending enforcement matters. And it sounds like that didn't happen here. And it sounds like that's not a good procedure. I don't think that's a procedure followed in other cities. And it sounds like you should change your rules. But you cannot penalize Supervisor Farrell because the commission had a breakdown in procedure or didn't follow procedures. Your executive director chose not to bring charges within the 4-year statute of limitations, even though they knew about it 3 years, 10 months earlier.
Okay, I got one more question, and I apologize for monopolizing the time, but another hypothetical to help me understand. So let's say that charges are brought someone complains about a campaign in November 2010 or December 2010. We look at it. We don't think there's anything there. Time goes on. The FPPC, in their investigation that we're a part of, learns, wow, there really is something going on here. Okay? And why wouldn't the discovery rule apply there? So you didn't know at the time,
right?
In 2010. You learn 2 years later. Then isn't the question whether or not the supervisor really did have an agency relationship with Mr. Lee?
Now I understand your question. The discovery rule is based on the situation where a defendant or someone intentionally, fraudulently consciously, affirmatively hides information from the government that they couldn't find under kind of a reasonable person standard, okay? And conducting interviews is reasonable. So what happened in the Boatwright case is, again, I don't know all the facts, but Senator Boatwright left some financial holding off of his form. And there was no way, you would never know that. There'd be no reason to know that. There was no complaint filed. I don't think it could be learned about during a public search. Some lawsuit happened years later. Part of that lawsuit was it turned out that Senator Boatwright had this financial interest. So the concealment was that the government agency or the defendant could not have figured out that Senator Boatwright left the information off of that form based on its own, whatever reasonable inquiry would be. Here, you had the reasonable inquiry. The Ethics Commission sat in on the interviews. There was no concealment. There was nothing fraudulent. They saw the emails. They sat in on the interviews. There was nothing that was concealed from the Ethics Commission. By October 2012, 2 years before the statute ran, the Commission knew what Chris Lee had done. So there's no concealment. That the concealment also, it's an important point. It has to be fraudulent, it has to be intentional. It has to prevent the government from being able to file charges within the period. And that just didn't happen here.
Thank you.
Mr. Keene.
Thank you, Mr. Chair. Mr. Sutton, I have a few questions that I want to ask, and I'm going to ask them. I made an allusion to Watergate a while back. And those of us of our generation will remember one of the things that happened in regard to the inquiries relating to Watergate had to do with the president and the people around him, and the famous aphorism, what did he know and when did he know it? That's what I want to pursue a little bit with you now. A few weeks ago when you were here, you were asked by Commissioner Andrews how much, we know that this fraudulent coordinated committee got a couple of $100,000 in campaign contributions, and they spent that, a couple of $100,000. Commissioner Andrews asked you how much in total did Supervisor Farrell spend in his own campaign with his committee? And your answer was, oh, I'm sorry, I don't know that.
It's approximately
I got
$260,000.
that information. Yeah. About $260,000. Right. $260,000. That's what he spent for his entire campaign. Yet at the same time, in those last weeks of the campaign, there's campaign activity clearly going on for him in Pacific Heights to the tune of another $200,000 being spent out there. Pacific Heights is not a vast territory. Wouldn't that raise some inference that Supervisor Farrell would wonder, where's this $200,000, all of this stuff that's being spent on me to help me defeat my opponent, all these hit pieces, where's that coming from? Wouldn't that raise some inference that he knew that, or at least would inquire?
Well, he or his campaign staff certainly did what the members of the public did, is they went to your website, and which requires, as you guys talked about...
I'm asking what he did. I'm asking what did he do?
Which requires, you guys talked about earlier, 24-hour disclosure, and they were able to learn what the public knew, which there was a committee called Common Sense Voters that was raising and spending whatever it was spending, and it was filing reports on a 24-hour basis. And what he testified under oath to the FPPC, what the FPPC agreed with, and what your executive director agreed with, is that he had absolutely no idea of how that committee came into existence.
No idea, no curiosity, it's just how wonderful.
Of course, he had the same curiosity.
Let me move on.
No, the same curiosity.
You've answered the question.
The same curiosity that the opponent had about the $90,000.
Can I ask you another question, or are you going to filibuster? Can I ask you another question?
Of course you may.
Please. All right. The other question is, can you represent to us, since Supervisor Farrell is asking us to go ahead and exercise our equitable powers, in effect, in regard to waiver, because it's not something we're required.
It's not waiver.
Well,
it's not
let
waiver.
me finish the question. You know, you got a problem, sir. You had it with Commissioner Herr, and you have it with me. I won't interrupt you. Don't interrupt me. Let me ask the question, and then you can answer the question in any way you want, okay? Can you represent to us that Supervisor Farrell had no part in the solicitation of $200,000, $150,000 of which comes from a gentleman named Tom Coates, $50,000 of which comes from a gentleman named comes from a lady named Dee Dee Wilsey, two very socially prominent people in Pacific Heights, part of his circle. Can you represent with a straight face to this committee that Supervisor Farrell had no part in the solicitation of those funds?
I can repeat.
Can you represent that to this committee? We don't have Supervisor Farrell here because he won't come. But can you say he had nothing to do with getting that money from those two people? Can you do that, sir? Yes or no?
I can repeat.
You can't.
I can repeat what he said under oath to the FPPC, which is that he had no knowledge of or interactions with any of the activities of the committee.
Thank you. You haven't answered the question whether or not he had anything to do with the solicitation of those funds from those two very prominent people who were close friends of his, and the idea that they would give that money to some little schlump like Chris Lee is absolutely absurd.
Any other? Mr. Sutton, just one question. If the forfeiture letter had been sent out in August or September of 2014, and knowing the facts as the fact that this supposedly common sense voters committee was really part of Supervisor Farrell's committee, you concede that this commission has the obligation to take some action. Would it have that obligation?
Well, I don't know. I certainly agree that the commission could take an action, whether it's forfeiture, whether it's an administrative fine or a civil action, if it was in August or October, of course.
In other words, and don't you believe we would have an obligation to do it, to hold some kind of a show cause hearing and let Supervisor Farrell show how he was innocent of any wrongdoing and that this may have been a terrible campaign violation, but he was innocent?
I appreciate your question, but the way I would answer it is you did do that. Your staff for over 2 years was involved in an investigation where you sat in on interviews, you reviewed emails, you conducted that investigation. They did that. Now, the commissioners didn't do it because investigations are done by staff. Investigations aren't done with the commissioners. They're done by staff. And then the staff decided the same thing the FPPC decided, using its discretion that Supervisor Farrell shouldn't be charged.
Well, I can guarantee you, at least as one commissioner, that had the stipulation that was entered into with the FPPC in August, September of 2014, had that been brought to my attention, I would have moved to take some action.
I appreciate that. We certainly appreciate that.
And the thing that troubles me now is that you are asking us to say, make legal decisions on legal issues about which lawyers can disagree. You're asking us to take action with saying we're going to preclude anybody, any judge, dealing with the issue.
If you're talking about the statute of limitations issue, I would say that you are public officials who have a legal duty to not bring matters after the 4-year statute of limitations, which is a limitation of your duties in the law. The same way that if the district attorney doesn't bring charges and the public defender would criticize that. And again, obviously, some of you are concerned with the decisions of your executive director. We would posit that maybe getting a new executive director is a good opportunity to revisit these issues so that the commission in the future can make a decision or can review what the decision that its staff is making about whether to move forward. But unfortunately, you are bound by the law. You have a duty to not act now.
And Commissioner Andrews.
Mr. Sutton, I have a couple questions. A statement first, and then a couple of questions. I feel fortunate to work for a nonprofit here in the city, and it gets lots of donations from many caring San Franciscans and beyond. And it's a what I would consider sizable nonprofit, multiple millions of dollars. And I have to tell you that in relation to the budget size or in relation to any gift that comes to the organization, percentage-wise, in the same amount, I would know not only the dollar amount that came in, but when it came in and who it was donated by. That said, I was wondering if you have any understanding or knowledge of the donor acknowledgement process that Supervisor Farrell and his committee did. Anyone who donated, is there a letter that goes out on behalf of the committee to thank them for their contribution, both his primary committee and this secondary committee?
Well, and I think there might be a misunderstanding here. Supervisor Farrell, the only connection, the only thing involvement between his committee and the Common Sense Voters Committee were the 3 emails that his consultant sent to the people who ended up setting up that committee.
I understand.
So in other words, but his campaign people, his staff, they had no involvement at all. So they wouldn't be acknowledging donors. They didn't. The only way they knew who the donors to the committee were is from your website.
My question stands.
Yeah.
Well within the committee to reelect Mark Farrell. Do you have any knowledge or understanding of what their process was?
Only the
not
most
the Common
general.
Sense voters.
Yeah, only the most general. That they would have sent a thank you letter.
They would have sent a thank you, and you wouldn't know the timeline in which they do it. We internally at my organization do it within 48 hours. We get that letter.
I only in general.
Okay.
Yeah,
that's okay. Thank you. And it may be known, and I just need to be reminded of it. Do we know that what's the timeline between the time of the donation? I mean, this is important because I go back to my original question, and thank you, Commissioner Keene, for bringing it back up. I'm still looking at the total expenditure that happened compared to the 190+ thousand that came through in support of Supervisor Farrell. I'm wondering, when was that donation made? Those 2 donations, 150 and 50,000. I mean, those are large numbers. And the reason why I mention that is because in your social set, and I often say to my staff, look, if a big donation comes in and it's from an individual, you need to let me know, because I run around town and I see people all the time, and I would be remiss not to acknowledge them for their wonderful, generous donation. And I was wondering the amount of time that went by between the time that the donation was made to Common Sense and the election. And for those 2 donors, significant donors, it would be hard to believe that Supervisor Farrell wouldn't run into either one of those donors over a period of weeks and months to acknowledge it, whether he brought it up, whether they brought it up, to say, look, I just want you to know I really support you. And because of that support, I made this particular donation on your behalf. Because that's what I would want to hear. Like, if it happened one day and then the election happened the next day, then you go, well, just not enough time went by. Right. But if months go by and I'm at the gym, I'm at the Bay Club, I'm hanging out, whatever is happening over a period of months, it would be hard for me to believe that one would not have an acknowledgement and understanding and full awareness that 2 individuals fully, if you look at the broadest view of expenditures made to reelect Supervisor Farrell, about 40% of the overall expenditures. So
I do know that all Common Sense Voters raised all its money roughly the 5 weeks before the election. So when the actual contributions came in, I don't know. But what I do know, again, is what Supervisor Farrell told the FEBC under oath, is that he only learned about the contributions by going on your website, and they filed reports, and they would see when the money came in. And that's when he learned it. And I also know that he told the FEBC that he did not have any discussions or interactions with any of the people involved with the committee, the donors or otherwise, during that time period.
So this is a question to the attorney commissioners. So in discovery, let's say we would move forward. We would not accept this waiver of forfeiture, and we would move forward. Would not texts and emails and such be a part of discovery in finding out the engagement, the communications that Supervisor Farrell had with not only Mr. Lee, but also with the two major donors?
We have subpoena power, and we can issue subpoena ducas tecums.
And city attorney can correct me, but if the motion that was made by Supervisor Keene passes, the waiver doesn't go out, the forfeiture letter goes to collections, and we're out of it. We have nothing more to do with it at that point.
Commissioner Andrews, if I can answer your question. The FPPC did ask for all those emails. Every email between Supervisor Farrell or the people who worked on his campaign and whomever, all the people involved with common sense voters. And Supervisor Farrell and his campaign produced boxes of emails to the FPPC, which the Ethics Commission staff also had access to and looked at. And again, the only interaction between anyone involved in the campaign and anyone involved with common sense voters were the 3 emails from Chris Lee to whomever it was at the very beginning. And there were no emails that the FPPC found. And they didn't only ask Supervisor Farrell and his campaign for emails. They asked Chris Lee. They asked the consultant for the Independent Expenditure Committee. They did that investigation, which of course is appropriate. That's exactly what they were looking for, is those kind of connections. And they found absolutely no connections whatsoever between Supervisor Farrell and his campaign and the Independent Expenditure PAC, except for those 3 emails.
And they interviewed the donors as well?
I know that they interviewed the large donors, or they tried to interview the large donors. Mr. Bell might know. I don't know they interviewed everyone on the list.
Thank you.
We requested the FPPC's file after the fact, and there's no information of any interviews of any of the donors. And to address one other question, the timing, in my timeline that I provided you, Mr. Farrell had a 2-hour meeting with Dee Dee Wilsey on October 6th, apparently to get a $500 contribution. 2 weeks later, she gave the $50,000 to that committee. 3 days after Mr. Coates had an event for Mr. Farrell at his home for his committee, he contributed $100 of the $141,000 to the phony Independent Expenditure Committee.
Any other questions? If I can just make one correction, I think it's important, though. What's before the commissioners, as I understand it, is not a waiver request at all. It is that Mr. St. Croix issued the letter, and now he wants to revoke the letter. And that's what he's explained to me, and that's what I believe the letter says, and that's what I believe the agenda item is, just whether to revoke the letter.
Any other public comment?
Good afternoon. Robert Van Ravensway. I was on the civil grand jury in 2013-14, and at the time some of this was going down in July, August 2014. I was before you with a number of our findings and recommendations, one of which was that you, the commission, are the policy-making body and set policy for the Ethics Commission, not the staff. And you agreed with that and put that into the, that you agreed with that finding. And I think staff was fully aware of it. And I think at this time, you see staff sort of setting their own policy with regard to when to seek forfeiture. I also want to mention, because I don't think it's been discussed here very much, is that forfeiture is seen as a different sort of penalty then a fine or jail, for that matter, is considered an action against a piece of property, not an action against an individual. And in many semi-criminal settings, forfeiture happens rather quickly, and the burden is usually on the owner of the property to show that it should not be taken, as opposed to on the law enforcement agency showing that it should be taken. There's a very sort of simple initial threshold, and in this instance, I think that threshold is met. Here's the sum of money that was obviously used improperly, and basically you're asking for its forfeiture. So I think you should take that into consideration as you go forward with this. Thank you very much.
Thank you. Any other public comment?
Larry Bush, Friends of Ethics. Just to put on the record, I obtained and provided to the Commission a copy of an email from the FPPC to the Ethics Commission staff dated August 28th, I believe it was, stating that the FPPC had prepared a stipulation. It attached a copy of the stipulation and asked the Commission whether it chose to issue a joint statement with the FPPC at that time, and provided a copy of what a joint statement would look like. There is no record from the Ethics Commission records through an immediate disclosure request of any response that was ever sent back to the FPPC.
Thank you.
My name is Ken Miller. I'm a resident of District 2. I've known Mark and Liz Farrell for many years. I've known their children for as long as they've been alive. I know Mark's character, and I know his values, and I am delighted to witness to the high ethical standards of this good man to anybody who wants to listen. I volunteered many hours on Mark's political campaigns because I believe that his high integrity and ethical standards represent the best that we can hope for in our public servants. And from that experience, I believe I can state with confidence that the actions of Mark Farrell, the candidate, are guided by the highest ethical standards and integrity, just as are the actions of Mark Farrell, the father, the husband, the businessman, and the friend. That was it. Thank you very much.
Thank you.
I'm Bob Planthold. I support the withdrawal of any waiver letter, and I suggest letting this move forward will make for enough complications. There's going to be more light shed and more information required and provided. But despite all the questions and the suggestions from the commissioners, I'm basing my comments on what the two attorneys have said. Mr. Bell raised a point earlier, and that goes to there's no indication that Mark Farrell gave specific instructions to his campaign consultant, whether it's along the lines of, did you read the required laws, whether it's make sure you follow the laws, whether it's don't get me in trouble. He said there's no indication. If that's the case, that indicates a casualness, a sloppiness, which then goes to the question of agency. Did he properly instruct his agents? If he didn't say, read the law, follow the law, are you sure you know what this means? Are you sure you know what you can't do? If he didn't ask those questions, that's a sloppiness on Mark Farrell's part. We also heard from Mr. Sutton that the only way Mark Farrell found out about these contributions was by going to the ethics website. What nobody seems to have asked is, why did he go to the ethics website and when? What prompted him? Where did he find out that there's something he should look at? And that also tells me somebody was telling him something's wrong, but we don't know who. And I think the timing on that also is something that is relevant. Why you should say, withdraw the waiver letter, let forfeiture proceed, and then if people want to fight it out in court, maybe there'll be more information provided.
Thank you. Any other public comment?
Good afternoon. David Pilpel again, speaking as an individual. I had 4 points at this time. One, this has turned into a good commission meeting with lots of back and forth, and I think some of us are learning a lot. Two, the Sutton letter that was provided to the public initially only had the odd-numbered pages, and I wanted to thank the staff for fixing that. We've all had a chance now to read that full letter. Three, the proposed letter actually has, I believe, the wrong dollar amount. So if the letter does go, the amount should be corrected. And fourth, although I have not been involved in this and have only learned a bit through the commission meetings, I wonder out loud if Common Sense Voters, or CSV, was the entity that was found to have become a candidate-controlled committee. Why shouldn't CSV be the entity that needs to forfeit? Why should it transfer to the supervisor? If CSV is the entity to which these contributions were made, should not they have to forfeit? And perhaps there is still an opportunity to do that with the estoppel and concealment and whatnot tolling. So that's my question out loud, is whether CSV is really liable for this amount rather than the supervisor. Thanks.
Thank you.
Hi. My name is Vince Courtney. I've been active in city politics here in San Francisco for well over 40 years. I know a lot of supervisors, mayors, what have you. And I just want to ditto what a prior speaker said about Mark. I know him to be very credible and very pointed in making clear that he wants everything squeaky clean. But more relevant to your discussion, though, I just learned 10 minutes ago that Michaela Aliotto was involved with this internal or independent expenditure campaign. At that time, she had much more access to money people in District 2 than Mark Farrell. She was raising money for him. I know because she asked me for money. She knew Tom Coates. He was one of her contributors. I don't know how well he knew Mark Farrell. It is not incredulous to say that he didn't know about those 3 emails. She was hell-bent on raising money for a candidate for Mark and against Carolyn Riley. The reason I didn't give her money, I'm the head of or executive director of an organization called the San Francisco Alliance. It's business and labor folks. All our labor folks, or most of them, were supporting Carolyn. Several of the business people were supporting Mark. We didn't have a majority. We wouldn't take a position. But most of the unions, I'm a union guy, were supporting Carolyn and think to this day that she would have done a good job. Okay? But it is not at all inconceivable to me that Michaela Aliotto was going to raise that money one way or the other. She didn't need 3 emails from Chris Lee. Thank you.
Thank you.
Good afternoon, Commissioners. Thank you. My name is Jim Maxwell. I'm a neighbor of the Farrells. I've watched Mark. We moved in shortly after he graduated from high school in 1992. And I've known him, watched this young man grow up, become a real force here for the city of San Francisco. And I'm not here just speaking on behalf of myself today, too. I am the president of the Small Business Network, and we've worked very closely with Supervisor Farrell's office over the years on small business issues. And in fact, when Mark decided he was thinking about running, he knew that I was very active in small business issues, and he came and asked me, what do you think I should do? Do you think I should do this? And I asked, why would you do this? And then I come here today and I have to ask myself again, why did you do this? Because this just is very difficult for me to sit here and listen to, because I know this man's character, I know his family, and I know how he ran his campaign, because I was sort of there at the very gestation of it. And he is above question the most highest integrity person that I know, and that has done some fabulous work for the city. And I introduced him to a few people that I knew in the business community, and every single one of them asked him the same thing. Why would you run for supervisor? You've got a lovely wife, you're raising a family, you've got a good job. What are you thinking? And he said, it always came down to, I'm born here in San Francisco, I grew up here, I'm raising my family here, the same district that I started in, and I want to make it a better place for San Francisco and for San Franciscans everywhere across the city. And that's been his goal, and what his actions have carried out every step of the way. And to sort of follow this and hear more of this stuff today and see that there's absolutely nothing that's come up in all these years of investigations and serious people involved in this, there's nothing that even vaguely ties him to it other than conjecture that, gee, he might have had a Jamba Juice with one of these people that live on Pacific Heights. I know Mark, and, you know, raising a family, running a campaign, he wasn't sitting around at the Bay Club having, you know, mimosas. So he was out trying to get elected, and thank you very much.
Thank you.
Charles Marsteller again. I just would say I'm very disappointed that the supervisor did not come here and make his own case. And he could explain to you face to face what he knew and when he knew it. As the commissioner mentions, I lived in that era as well. And I think that's really the problem, is he perhaps was advised to stay away. And I think that was a mistake, because I think there are unanswered questions that he could have come here to address directly. And I don't know if you could have asked him questions or if that would have been appropriate, but I sure think there's a lot of questions that still need to be asked of the supervisor directly.
Thank you. Any other public comment?
Chair Rennie, I have a question. Can we seek advice from the city attorney on this matter?
On what?
On the legality of the statute, and is that something that should be handled in public or closed session?
Well, that item number 6 was in the contingency that any commissioner wanted to confer with the city attorney, so that if you would like to invoke or request that we go into closed session so that you can discuss it with the city attorney, you can. So we will move to agenda item 6 before we vote on the outstanding motion.
Could I don't mean to interrupt you, Commissioner Herbert, but just a suggestion.
Sure.
And following up in terms of what you're saying. If we do that, and that's fine with me, that if we seek the city attorney's advice in what the city attorney thinks, I think we ought to do it publicly. We often get advice from the city attorney. We're asking them all the time in public and see what he thinks. I know what's going to happen, and it's fine. I know what he's going to say, because we've all seen the memorandum that has been prepared. I'm not disclosing anything by saying that there's an existence of a memorandum. So I'm perfectly content to have this discussion openly in terms of what the city attorney thinks relating to the statute of limitations, and I think that the public should be privy to that as well. Just a suggestion. I mean, I didn't mean to interrupt your motion, but I did. I apologize.
I mean, on the issue of whether it can be public or not, what I worry is that given the subject matter, given that we've been, isn't that basically a waiver that we're opening it all up? Which I don't know that we can do, but I'm looking to the city attorney.
Oh, I think we can. Well, all right, sorry.
If you wish to discuss some of the legal issues that presented during this hearing, I would request that we discuss it in closed session.
Question, point of order. Question is, do we have to do it in closed session? I mean, you might prefer something. That's nice, what you prefer. But is that something we have to do in closed session? We get your advice all the time in open session. It's not a question.
Let me call and ask Commissioner Hurd to make a motion under Agenda Item 6 that we go into closed session and see if you get a second. And because if the commission as a group is prepared to stay in public session, they obviously have a right to.
Sure. I am curious to the answer, though, to Commissioner Keene's question. I mean, is that just your preference, or is that do you see that as a requirement? What did you mean by that?
I think for the purpose of this item, that would be a requirement, that we should discuss this in closed session.
Why is it a requirement?
Given this matter, I think it's in the best interest of the commission, the best interest of the city to discuss these issues in closed session.
I'll make the motion then.
May I just interject one point before, and we take up the motion? I'll be very brief in regard to...
I think I'll let him have his motion first, and then you have your comment. Very good. Do we have a second to the motion?
Second.
All right. What's your comment on the motion?
Well, my point is that in regard to the privilege, like any privilege, the privilege is held by the clients. We're the clients. It's not held by the lawyer. So if the clients want to waive the privilege, the fact that the lawyer says, well, no, you shouldn't waive the privilege, we're the ones who can make that decision. The fact that he's uncomfortable with it is irrelevant. So the idea that we have to do it, even though we who have the privilege don't want to do it, is simply he's wrong on that.
When you say we don't want to do it,
I don't want to do it. I'm suggesting that we should.
Any public comment on the motion to go into closed session on item number 6?
I'm Bob Planthold. I want to concur with Commissioner Keene that the commission has to decide. But what I would ask is, if you do go into closed session, could you at least make known to the public beforehand what questions, what issues you're going to ask? That way we can better understand when you come out of closed session what might be the basis for your decision. If everything is held sacrosanct, and you come back and you make a decision, we're lost, we're adrift. At least if you do go in, and I oppose going into closed session, I think it's a good idea to air this, because so much has been kept hidden, unstated, unasked. At least let the public know what are the issues, what are the questions you're going to ask. Thank you.
Commissioner Hurd, do you want to say what it is, the question that... I understand, but I want to respond to what is the question that you envision us to be discussing in closed session?
The topic is the statute of limitations.
Okay.
Hello, Commissioner Larry Bush. I think it's hard to imagine, given my experience with the city attorney's office, that you're going to get any advice other than the fact that a prediction that the court would find that the statute of limitations applies, but that the city attorney will represent the commission with whatever it decides, which is not a hard call. That's every day. I saw it so many times when I worked in the mayor's office. That's what comes back. You're likely to lose, but we will represent you. So what's the big decision? Secondly, I would point out that there is a certain irony over the fact that you had a stipulation sent to this commission, which was then hidden from the commission for months, allowing the statute to possibly expire. And now you want to have a discussion about whether or not the expiration should also be done in a closed session. The optics on that are not good. Thank you.
Thank you.
Charles Marsteller again. Yes, all the optics on this has never been very good looking, actually. And it would be a disaster for this body, I think, to rescind this letter personally, because I think, in fact, it's necessary for you to rescind this draft and let it go ahead under a forfeiture, because otherwise you can imagine the way this thing looks to the public. And I don't think it would enhance your reputation at all. I should point out that the chair made a reference to the item number 6. Are you planning to take up the executive session with the city attorney in the next item on this matter as well? You kept referring to item 6. This is item 5, at least on the agenda.
I said that item
table.
6 was placed on there in case it was necessary for us to go into closed session to deal with item 5.
Both issues.
Yes.
So you would be doing item 5 and item 6, which I assume has to do with 1114.
Correct.
Okay, so that was your thinking.
Correct.
Okay, the public wasn't too clear on that, I don't think.
I understand.
Why? Thanks.
And I will say, just for everybody to understand, is that item 5 is still open, and if we go into executive session and come out, we're going to deal with item 5 as well in public. Any other public comment? All right, I'll call the question. All those in favor of going into closed session?
Aye.
Aye. Opposed?
No.
It appears that the ayes have it 3-2, so we will go into closed session.
Francisco, Government Television.
Oh, it's just everything that's great wrapped up in one convenient package.
I don't know, it's just something I grew up on. Burritos are the best, man.
I just get the meat, rice and beans.
Sour creams and cheese. I like my refried beans.
Oh, I love salsa verde with my burrito, but then obviously pico de gallo with the chips.
What more could you ask for?
Salsa. I like it kind of spicy.
Guacamole.
I love avocado. My dog's name is Avocado.
Every burrito I've gotten here is like too big for me to finish in one sitting.
With the mission style burrito, you just get so much more. And who can argue with that?
I think that burritos are the quintessential San Francisco comfort food at this point. A mission-style burrito is very embellished and kind of oversized. It's got a lot more ingredients in it than a regular burrito.
When you're going to San Francisco, be sure to come to La Cumbre today.
Edward Duran, and manager and proprietor at Taqueria La Cumbre. La Cumbre is a family-owned business. It's been in operation since 1967. The business was started by our founders, which were Raul and Micaela Duran. Burritos were something different, and Raul thought, well, with a flour tortilla and Grandma's recipe for the flour tortillas, we can stretch out the tortilla and actually make something bigger and make something that provides someone with enough food to get through the entire day. In other words, it was kind of the equivalent of a brown bag lunch, but in a tortilla.
They're portable. It's not uncommon to notice a person walking up Valencia and they're chowing on a burrito as they're walking.
The mobility of the burrito is really the appealing aspect of the burrito.
I'm Patrick Cosere, and I'm the owner of El Faro restaurant. My wife and I bought it 8 years ago, and she used to work here in the 80s. It's a good food, and it's a good price, and it's pretty big size burrito, pretty big meal. El Faro has a big history, probably the biggest history of any burritos in it. They've been here since 1961. At one time was the only place where they made burritos in San Francisco. They said it was big lines, many people working here. The original owner started El Faro, Mr. Febronio, and I guess, had 5 or 6 at one time. We've been trying to keep it the same as it was originally. That's why many people ask, is it the original owner still here? Because we try to make it the way it was before, you know. Well, I wasn't around. I really don't know. This, people here claim the first ones, and people on Valencia claim the first one over there.
Hector and Fabrono, the group that started El Faro, wonderful people. And when you start together like that, at that time, everyone knows everybody. And so, we all have our stories. They say they, we say we.
All signs point to a place called El Faro over on 20th and Folsom. Back then, this is in the early 1960s, it was a market, and a group of local firemen would come in regularly, and one day they wanted something besides sandwiches, so he whipped up sort of an enormous version of burritos for them. That's kind of where legend has the mission-style burrito sort of having its birthplace. And then La Cumbre was the next taqueria to come on the scene later in the 60s.
I don't think it's possible to narrow it down to just one. There's a lot of great burritos out here.
Taqueria Cancun.
El Farlitos.
La Taqueria.
Papalote has always been one of my favorites, and the carne asada here is about as good as it gets in San Francisco.
Los Coyotes.
Taqueria Guadalajara has 80 different salsas.
La Espiga de Oro.
La Cucumber.
My favorite spot is La Corneta. They have the best prawn burrito in the city, hands down. Come on, it's not up for debate.
El Castillito up on Church.
El Burrito Express out in the Sunset. That's where I live. They're pretty great, and they deliver.
I mean, in San Francisco, you can't go wrong. You're not going to go a week without hitting the taqueria like once or twice. It's kind of like a community center.
It's part of the fabric of the neighborhood, part of the fabric of the community. The burrito became kind of a go-to food for people who really, really needed to have something made quickly, had something made well.
It's a balanced meal.
I think if it all plays together, then I think that's the most important ingredient. It's not just one ingredient, it's kind of everything together.
And if you have all those ingredients meshing all simultaneously, that first bite you take is like having those Pop Rocks explode in your mouth.
They're so synonymous now with San Francisco that they're really closely intertwined, much the same way that, say, like fish tacos in San Diego are, or like steaks in Texas, or pizza in New York.
Good morning, everyone. Let me begin by thanking everyone for coming out today. Our mayor is here, and he has got an important announcement that he'll talk about some of the vision that he has as we grow in San Francisco. And I just want to welcome him for coming and for this great announcement. I will not let the cat out the bag. I will let him make that announcement. But I just want to thank Mayor Lee for his vision and his leadership. As many of you know, he was a public works director, and he knows what it takes to keep this city moving, and what the public works department needs to make our city comfortable and meet the needs of many of our city's requests. So with that said, welcome Mayor Ed Lee.
Thank you, Mohammed. It's a great time when you can rejoin the men and women in Public Works here in the center of Eureka and 22nd. And yes, we have a pothole to fill, don't we? But anyway, our office has been humbly announcing all the investments that we're making with our budget. And today is Public Works' turn to get a little love from our budget. Something Mohammed has been asking for a lot these days. And it's important because Public Works touches every single neighborhood of our city. Let me begin by saying that in our next 2-year budget, we've been experimenting recently with some enhanced cleaning crews throughout the city in areas where we've experienced growth, a lot more density of people living, and therefore the old habits seem to sink in. There's a lot of trash, a lot of graffiti, and other public works kinds of messes on our streets. And so we are budgeting. We have the numbers for you in the press release, but we're budgeting for enhanced cleaning because DPW deals on a 24/7 basis many of the areas that have seen growth that we don't know about, but people are living there. A lot of alleyways, a lot of areas of our city, and so we're increasing the enhanced street cleaning budget for Public Works to make sure that they can hit many more neighborhoods of our city. And you hopefully will not hear them work because they'll be working quietly sometimes in the late evening hours to get to these streets. Because quite simply, some of the trash and some of the things that are getting on our streets are being done in the daytime. So some of the crews will be out there at night, and they're glad to do it, but they'll be working as quietly as they can with low-noise machinery to be able to do it. An extension of that enhanced cleaning is something that has become very popular, but it began yet as another test pilot in the Tenderloin, and that's our pit stop program. That's the program where we seem to have a lot of people in need of bathrooms, and our old established programs of the J.C. DeCo's and some of the bathrooms that we built over the years haven't been as good in terms of making sure that people use them rather than our streets and our alleyways and our sidewalks. And so we are going to increase the pit stop program that has these mobile restrooms that people can use, that they're monitored, and that there's a politeness to them that I think people are welcomed, but to really get the service where areas where people are using our streets rather than our restrooms. And so we are having that mobile pit stop increase beyond the Tenderloin. There'll be one set up at 6th and Mission, I believe. And I know that there's another one also being set up, and I know other supervisors are kind of clamoring for it to come in their neighborhood. I know President London Breed is going to have a very specific discussion with you, Mohammed. I told her to talk to you, not me, so that she can get some areas in her area given a pit stop touch. But with that, with the increased pit stop crews, we are also in discussions with J.C. DeCo so that I think the experiment in some areas of the city have been very good with automated restrooms, but there are some parts of our city that simply abuse that automation. And so we're going to be working in negotiations with J.C. DeCo to kind of do a monitoring of those particular restrooms too, and probably enhance their maintenance and allow them to be used more in areas of the city. That'll be part of the pit stop crew. Many of our neighborhoods, of course, have been complaining about their trees. We are a city that embraces our trees. We want to make sure that canopy is rich, and therefore we've added another arborist crew to Public Works in this next year's 2-year budget, and they have a lot of demands on them. This crew will again be able to take on some 2,000 trees out of a 21,000 tree canopy that we have in the city. Almost 30,000, if I'm not mistaken. But it's another effort on our part to use the prosperity of our city to make sure that the needs of every community get touched. And when it comes to trees, there's a level of maintenance that has to happen, and we're glad to add yet another crew of arborists to the whole DPW maintenance crews. So they'll be out there, and we hope that particular crew can help also with some of the landscaping challenges along Sunset Boulevard, but also many of the street trees that aren't taken care of in this neighborhood as well as elsewhere can be touched on a more regular basis. It's not the final answer. We're going to have to probably find a more long-term sustainable resource funding for our street trees. But this, while we're doing that, we're going to add to this crew and make sure that our arborists get the support that they need. We're on the street today because, quite frankly, while we're doing better than years in the past, we want to add another $98 million to the 2-year DPW funding specifically to do road resurfacing. Many of our streets have not been touched, and they're broken up by all kinds of different reasons. We happen to be on a street where we're encouraging a strong bike path to happen, and yet we've got some causes underneath the street that could turn into ugly sinkholes down the road if we don't take care of them now. This street of Eureka happens to have a cycle where it'll get repaved in the next couple of years, but while we're doing so, we don't want injuries to happen. So we're going to experiment with this crew today on some quick patchwork that will be more than a demonstration. It'll be touching up our streets throughout the city while we await for the total resurfacing that has to happen with good engineering as well as good planning, as well as appropriate notification to all of our property owners and our residences, so the disruption can be welcomed because they can actually see some benefit out of it. Finally, our 2-year budget will also have something that's another near and dear to me. Public Works has been a great partner when it comes to job creation, and I know that our unions working with Public Works have been very gratified when we work with them, whether it's the gardeners, whether it's the cement masons, whether it's the asphalt or the general laborers folks, or whether they're arborists. All of them have been participating in a very strong apprenticeship program that has been at the heart of DPW's workforce training program. And while DPW is a great leader in the summer jobs program and getting all of our youth excited, on a long-term basis, we have job skill sets that reflect the trades that are at the heart of Public Works. And I want you to know that in addition to the engineering and the construction management and the project development, on a day-to-day basis, apprentices are called upon and they work with our folks that are doing all these incredible day-to-day jobs that everybody needs to have happen. And I want to just thank all the unions, the labor force, like men and women in Public Works, their supervisors, because welcoming an apprenticeship, some 200 of them in the last 5 years in all these different trades, has allowed them to really build careers. And this is what I'm talking about. These men and women behind me, they've got good careers. They've got solid jobs. They are proud of their work. They know that when they leave a street, or of whether it's trees or the patchwork or the resurfacing, or whether it's cement and doing all the corners that require us to have ADA access, they're proud of their work, and they know people are safer and traversing the streets safer, and they, of course, they beautify our neighborhoods. So I want to just thank them, but also know that their good work is rewarded by an enhanced budget in all these areas. But I say to them, too, that the apprenticeships program is important to us because not everybody can be an engineer or a project manager. Not everybody can be a tech or health worker. But these are good, solid family jobs that they have that I'm very proud of. And I'm proud of them because these apprenticeship is important to the city. You can train people in all these trade crafts and allow them to grow their entire families in the San Francisco Bay Area. And, of course, I promised them, too, I got to build more housing for them and for the workforces that they represent as well. We'll be doing that, and they'll be proud of a city that supports them, but also a Public Works department that is the center of everything that we do. You'll find every great event, there's a Public Works person that's involved in it, whether it's Super Bowl 50, the U.S. Conference of Mayors, or your neighborhood block party and Halloween party. Public Works has to be there for everybody, and I'm very proud that the department that I led is now being led very effectively, got good managers, got good project managers, such that our general hospital can be on time, our public safety building can be on time, more and more things will be on time, even Muni will be on time. So this will be a great announcement. I'm glad to join. And now we're going to have a little demonstration of patchwork. It'll get me more focused. And then I'm going to go over and thank some people that have been doing an incredible job at our War Memorial. Thank you. All right.
Thank you very much, Mayor. It's your vision, this work that you started many years ago is paying off. Our city is growing, and we're here to do the people's work. I just want to thank you on behalf of our department, all the men and women who work hard every day, 24 hours a day, 7 days a week, to keep our city clean, green, but also our infrastructure. Starting with the street bonds, your commitment of continued paving at the same level. We've been paving over 900 blocks every year, and this budget will allow us to continue doing that for the next few years. That will also allow our PCI score for our streets to get better. The enhanced residential cleaning program That will allow us to go into some of the alleys in the city and allow the firefighting force that has been going in there to go back to the various neighborhoods to do the work that's needed in the neighborhood. And of course, our trees are very, very important. And your commitment and your leadership to make sure that we have an additional arborist crew, but also the funding for all the apprentices, cement, labor, asphalt workers, arborists, all those apprentice programs, their jobs. These jobs make a huge difference in the lives of the people who live and work here, but also allows them to take care of their family. So we're very grateful with the economy of the city, and we're grateful for your leadership, and thank you for all that you have done for Public Works. Thank you.
All right. You ready for a demonstration?
The shovel for the mayor. Give the mayor a shovel here. That's okay. We'll take that one right there.
We lived in the Bayview since 2001, and before that we would come to the Bayview for all sorts of activities, and we loved it, so we had to move here.
Well, I'm from here, right here, Bayview, Hunters Point, born and raised, and been pretty much living here my whole life and working here my entire life, and my entire life has been dedicated to community service.
Bayview Hunters Point is still San Francisco. It's still the neighborhood. It's still the city I moved to 30 years ago, almost, and I think it will be for a while. I love it. I love that it's a working class neighborhood. It's a mixture of a lot of different kinds of people. Our diversity really is our strength.
I'm born and raised in Bayview, and I want to be able to give back in any way that I can, and my passion and love for cooking and being a Bayview resident, it just goes hand in hand to me.
People are very friendly and very warm, very engaging. There's a lot of different cultures and mixtures of people from all races and ethnicities and ages that I interact with on a day-to-day basis.
Well, I'm a Bayview native. I lived in Bayview all my life, which is 26 years. I love Bayview because it's familiar, it's home to me, and I just love the sense of community around Bayview.
I love Bayview. Bayview my home because of the diversity, the love, the culture, the food, the community, the people, the kids. Bayview is lovable.
Well, it's unfortunate that so many people think that Bayview Hunters Point isn't the great neighborhood that we know it is. Every weekend we're doing volunteer days with groups of people who come in, and inevitably somebody will say, you know what, I haven't been shot. It's beautiful here. The weather is nice here. The people have been very friendly to me. The houses are gorgeous. The gardens are beautiful.
Bayview has a history of being an unhealthy community due to the shipyard, the naval plants, the other toxin that's been released into the community, into the ground, into the water sources. So people see that as being an unhealthy environment. There's also lack of fruits and vegetables and grocery stores.
Quesada Gardens, I think, is an example now of a beautiful place and a place where health thrives, the health of the environment and the health of the residents, but it wasn't always that way. There was a time when people were living in isolation from one another and in fear, but it was Carl Page and Annette Smith who started to plant flowers here and there around the block, and that changed everything.
Once you get people coming together and doing something at large and realize you have more in common than differences, then you can make a change in the community. Looked out our window here and we saw an empty lot, and the lot was desolate. It was weed infested, had trash, and we decided somebody's going to do something about it. And the mayor looked back and we said, you're the somebody. We couldn't do it by ourselves because you never do anything by yourself. And we got in touch with Quesada Gardens. They gave us the contacts, the inspiration. They worked hand in glove with us in the garden until it became a success.
The gardens do 4 very important things. schools. They educate youth about where their food comes from and really opens up their awareness about that. The second thing that it does is really begin to get you thinking about what they're eating and what's going into their body and how that's contributing to their overall health and wellness. The third thing it does is it gives the youth and their families an ability to actually access this food and to take it home, to cook it, to experiment with it, to learn about different ways to prepare it that are healthy. And then it also provides mental and spiritual benefits.
That, to me, is an educational process that needs to happen for the whole family, not just the children.
So now we are no longer isolated and fearful, which is my definition of unhealthy. We are connected and we are strong.
We live in what's called a food desert, and now it's being changed to a food swamp. So for the population, there's really no ready access to fresh produce and high quality foods. And I think, a lot of times our children just don't know it's unhealthy. And so really what we're trying to do is raise their awareness, but also provide a means for them to access that food and incorporate more of it into their diets.
We are working towards being healthy, and this is the first step, is engaging our children and getting them aware, because they go home and tell their parents everything. With the Dare to Dream program, we do a number of arts programs, and it's for the kids of Bayview. So we offer all kind of stuff. In one class we offer is the healthy cooking class, which I teach, and I love it. I tell them if you eat, your green vegetables, you're going to be a green monster. We even
All right, the commission is back in public session, and the commission has voted not to disclose specifically what was discussed in closed session, except to advise that no decisions were made as a result of that closed session, in the closed session. We'll now go back to item 5,
need to vote.
Where there is outstanding Supervisor Keene's motion. Do you want to repeat it again so that it's clear?
Sorry, I think we need to vote on the closed session again in public.
All right.
We have to do it twice.
We have to vote on the
same thing again in a closed session.
Do I have about not disclosing what was in the closed session?
Except the fact that we made no decisions on anything. Right. Okay.
It's still, yeah.
All right, somebody so moved?
So moved.
Second.
All in favor?
Aye.
Well, I guess
Public
should have public comment before I take a vote. But I think, given the time, all in favor?
Aye.
Opposed? It's carried unanimously. We'll now go back to item 5, where we have pending the motion by Commissioner Keene. If you would restate it.
Yes, Mr. Chair, I move that the commission overrule the decision for waiver and the request for it by the executive director.
And by that you mean to not send the letter that the executive committee director was recommending being sent.
Exactly.
All right. And I seconded that motion.
Okay.
May I make a comment?
I guess public comment again.
Do we have to do public comment again?
All right. Hearing no public comment, I will call the question.
May I make a comment?
All right.
Chair Rennie?
Sure.
A couple things that I'd like to say. First of all, I don't think the matter that's before us is an issue of whether Supervisor Farrell committed fraud or committed wrongdoing, and I really don't think that's the issue that's before us. My view on this has nothing to do with whether he did or didn't, because that's not what we're here to do. I certainly don't want to impugn his integrity or his character based on these allegations. I will say, though, that after consulting with the city attorney, I do think that this is a close call. I do think that there are reasonable legal and factual disputes relating to the statute of limitations.
Any other comment? I also will add that to what Commissioner Herr said is that we are not making a finding if we vote in support of this motion. At least I'm not making a finding that Supervisor Farrell did or did not violate the various campaign laws that were covered by the stipulation by the FPPC. What I am saying is that those findings and the finding of the FPPC did demonstrate an egregious violation of the campaign ordinances, and that for us to say we're going to put it under the rug and waive it, I just am not prepared to do. I let it take its course, and some other fact-finding body can determine the correctness and whether or not Supervisor Farrell did or did not violate those campaign laws. All right. All those in favor?
Aye.
Aye.
Opposed? It's carried unanimously. Turning to item 7, which is adjournment. I guess I don't need public comment on that, so we'll declare ourselves adjourned.